Be meaningless.
And date may be fixed immediately after. Not
Because already so many matters are fixed. So
I
let it come in the month of first week of August,
July.
July. Right then, let us have it on 20 July.
May I please, I want to mention item 20. I have instruction not to praise this matter.
Item 20. On the submissions made by the council appearing for the petitioner, Mr.
And Talukdar.
N. Talukdar, that the writ petitioner does not wish to press the petition any further. The writ petition stands dismissed as not pressed. Yes. All right. Interim orders, if any, stands vacated.
One of the matter also kept CAV relating to single notice for multiple years. In the meantime, our High Court is pronounced. Can we not place that?
You give the number, we'll have it listed on Monday.
Not.
Monday?
I'll give it.
Also, I get to mention I have about 24 also. I have to file an affidavit in this case also. I have taken the consideration of the other file also. To make a 3 weeks.
24.
24.
The request made on behalf of by Mr. Lupaite, Standing Council, matter stands to be listed after 4 weeks. Obliged.
Maybe the lordship.
Yeah.
I filed a new case yesterday, madam. I paid for a lordship. If your lordship sent madam today.
Today?
Madam.
Why?
Madam, the order was there in 2022 to have some medical examination, and thereafter medical examination. To conduct a medical examination on the petitioner.
What is the claim you are making?
Claim is without adhering to the complying to the order passed on 2022. Now they have on 9/6 they have transferred me and converted me to the alia post.
That we'll examine, not an unlisted matter.
Yeah. But she's a lady, madam.
Whatever.
Suffering from multiple diseases, madam.
15th, not before that. 15th. Monday.
May I please, I beg to mention item 46.
Yes.
There is a transfer matter, they have filed an affidavit. Would like to reply, kindly fix it.
46.
46.
Counsel for the petitioner, Mr. D. Gogoi, submits that he'd like to file an additional affidavit.
Reply.
Rejoin the affidavit file. Released again in July.
The respondents had agreed to a adjournment subject to fixing it before vacation. That's no urgency. Transfer.
When was the affidavit filed?
Affidavit was filed 3 days back.
3 days back. So let it be in July. Some interim order is there.
Yes, my lords.
17th July.
My lords.
Interim orders, if any, will continue. This is for admission.
My lords, yes.
This is for admission.
Public.
Wait, please, your lordship. I beg to mention for this kind of matter, admission space. Last decision 18, maybe may come after vacation.
After vacation.
Any date.
22nd July.
20.
May please, your lordship, I beg to mention item 13, the DDL is today.
Item
30.
30.
Yes, my lord.
Yes.
Lordship, we seek further time to file our affidavit in this matter. We have conveyed this mention to the other side. Your lordship may fix any date.
You have informed the other side.
Yes, my lord.
Petitioner. Item 30 on the request made by the council for which department?
Agriculture department.
Agriculture department. Matter stands deferred to be listed again on 22nd of July. Royal. Monday.
Lordship, I beg to mention at paper 29, Lordship. Lordship, I have taken consider of the other side, Lordship. This regard, Lordship, we have filed our counter affidavit that is being ready, Lordship. Matter will come after vacation, Lordship. In the meantime, we will file our
Council appearing for Mr. Sutradhar.
Yes, Lordship.
Appearing for the respondent. Submits that you would like to file the affidavit. Prayer made is not opposed by the council for the petitioner. Matter stands deferred to be listed again on 27th of July. You are for the Mr. Ketal, the repeat for the.
Please, your lordship. Listing of a matter for which we are
Monday.
May I please, your lordship, with the consent of the petitioner, I beg to mention item number 39.
39.
Lordship, we need 2 weeks time to file the affidavit. It has been already sent for vetting.
39 on the request made on behalf of the standing council, APDCL.
Yes, APDCL.
Matter stands deferred, enabling them to file file their affidavit, release this matter again on 27th of July.
Much obliged.
Your Lordship, I would like to request for listing of the matter for motion.
When was it filed?
2 days back.
Huh?
2 days back.
It should have been listed. Why is it not listed? Why
It's
do you
not-
need to make a mention?
It's not been listed yet.
Therefore, there must be some mistake, some defects. You can't bypass it by making a mention. You have to go and find out, talk to the registry, why the matter has not been listed. You find out and come back, and if it is not, if everything is clear, you make a mention on Monday.
Or Your Lordship, one more matter for admission.
Admission in July, 27 July.
My application. Chief, I beg to mention item number 45. I'm going to respond on oil legal in the
45 on the request of the council for the Oil India matter stands deferred to be listed after 4 weeks.
Lordship, like, if we permitted, they have already taken to twice adjournment. So if a short date can be
After vacation,
after. Okay.
That's why I beg to mention item number 60 of subject.
item 6-0.
Yes. Matter will be adjourned to 1 week. In this regard, we have brought third lordship to our client lordship.
Item 6-0. You are for the petitioner.
Yes, sir.
6-0 stands deferred to be listed after 2 weeks, 3 weeks.
May I please, Lord?
So I made a mention on 1st of June for listing of two arbitration petitions. It was allowed to be listed today, however, not on the list. So maybe on 18th.
18. Why 18? Why not 17?
17 in.
17.
7. Highly obliged.
With regards to item 48, on the other side, I'll bring for adjournment this one.
48. On the request on behalf of the Standing Council PNRD, matter stands deferred to be listed after 3 weeks. Mr. R.M. Deka.
Come up for
Yes,
motion
okay.
matter,
Huh?
because the notice is yet to be issued in this matter, madam. So matter may be listed in a motion column. There.
It is listed in admission, 48.
Yes, madam, but notice is yet to be issued in this matter, madam. I have checked the last order, madam. And the last occasion, they directed to take inspection as to why my case was not considered for promotion.
48. No notice has been issued. However, the matter is listed in the admission column, matter will be listed for motions.
Right.
On 22nd
My lord.
July.
Deeply obliged.
Lordship, in item 1, I have received instruction, Lordship. I want to bring this on record, Lordship.
You have to bring it on record.
Lordship.
Bring it on record, then we'll issue notice there.
Yes, Lord.
Lordship.
Third learned counsel for party will issue notice within 4 weeks. MS N. Bhattacharya, learned senior government advocate representing the respondents, submits that she has been posted with the instructions. She would like to bring it by way of an affidavit. Accordingly, matter stands deferred to be listed after 3 weeks. Issue
Lordship.
notice after 3 weeks, returnable 3 weeks.
Lordship.
You are appearing for all.
Lordship, and
The interim order, if any, passed early, will continue.
obliged, Lord.
Mr. D.J. Kapil for the petition.
Please, Your Lordship. My lord, I refer to order dated 25/5/2026.
Yet to receive any instruction, Lordship, that is, Lordship, it is covered by the Sanjay. The settled law, Lordship, it is Sanjay Kumar case, covered the Sanjay Kumar case, Lordship. At that time, he was minor, Lordship, after 13 years.
Santosh Kumar.
Sanjay Kumar, Lordship.
Sanjay Kumar.
Lordship. They stated that, Lordship, there cannot be reservation of vacancy till such time the applicant becomes the major. after a number of years, Lordship. After 13 years, they approached the before the court, Lordship. And he submitted the representation after 13 years, Lordship.
Your Lordship,
It's a covered case,
on
Lordship.
25/5/2026, that was the stand of my learned friend on that day also. But your Lordship directed them regarding my representation. But whether it was disposed of or dismissed of, that was the order.
Representation was filed. What has
Lordship.
happened to that?
At that time, he was minor, Lordship.
What has happened to the representation? Have you addressed? Have you rejected? Have you accepted? What have you done?
That was not received.
That
any
is the instructions you are required to furnish.
Lordship.
Get it. In deference to earlier order dated 25/5/26, the respondents were directed to place before the court the representation filed by the petitioner, praying for compassionate appointment. That the matter was fixed today. Mr. A. Chakraborty, the government entity, submits that the affidavit, the representation could not be filed. We did not receive the instructions, and therefore he prays for further time. Accordingly, the matter stands deferred, listed to be listed on 20 July. Mr. M. Sheikh appears for the repetition.
Obliging.
Obliged, Lordship.
In this case, the person with the recent judgment of the Honorable Supreme Court of the opinion that I need to file an amendment petition.
Counsel for the petitioner submits that he would like to file an amended petition to incorporate changes in view of the recent judgment of the apex court in Sukhendu Bhattacharya. Civil appeal number 7. Prayer made is not objected to by the respondents. Let proper application be filed seeking amendment before the court. Mr. Musari for the petitioner, for the BTC. Mr. ABT for the petitioner.
In this case, the petitioner, they are physically disabled persons having disability around 40 to 60%. Pursuant to an advertisement dated 30/12/2018 and Annexure 3. They have
Why this is challenged now?
my lord, at this stage, my lord, they are not challenging the selection. There are so many illegalities in the selection, but my lord, the pair is that they have been selected in the merit list, and out of the total merit list, my lord, only 511 posts was there, but at this stage, my lord, 150 grade 4 posts still vacant, not filled up.
But after 2018,
My lord,
when were the appointments made?
my lord, their limited pair is that since the posts are not filled up, all the posts are not filled up. Some posts are still lying vacant. My lord, their pair is that there may be a consideration, my lord. My lord, at this stage, my lord,
That will be opposed.
if they are eligible,
That is
found
opposed
eligible,
to the law, because there is a select list. Whatever posts they wanted to fill up, they filled up. You are not challenging the appointment of the selected candidates.
my lord.
If you are challenging the appointment of
Because of the
selected
delay, my lord,
candidates,
they are not challenging, my lord. But the posts are lying vacant.
maybe they'll re-advertise and fill it up. Where is your right to demand that you should be
My lord,
appointed in those posts?
My lord, at this fair, my lord, there are some other similar matters, my lord, WBC number 56/2023. This matter will be taken up along with that case, my lord. Let all matters be disposed of similarly, my lord. It is one.
When is that matter listed?
My lord, it was listed long back, my lord. It's likely to come in the after vacation, perhaps. WBC number 562/2020. This matter may come up along with that matter.
We can have it listed next week.
My lord.
What is the
Under 2022, they are saying that some candidates were appointed. They went and approached the
the authorities under the
So what
commissioner.
you-
And
Well,
there
you-
is also.
you get your
direction.
instructions, we see. Heard, learned counsel for parties.
My lord, may I pray, my lord, the social welfare department is not in existence as on date, my lord. So I'm appearing for only social justice department. They are seeking relief against social welfare department.
My lord, respondent number 8 are taking up the
So respondent 8 is the selection committee. You are seeking
state level
appointment.
recruitment commission, state level recruitment.
Who is issuing the appointment orders?
Commissioner secretary is also great party.
No, my lord, it
Commissioner,
is. One
chairman,
is-
state level. All are party, my lord.
Who is the department to be added now? Which department?
My lord, social justice. Social justice is already there, but
Ah.
the social welfare will be, my lord, department.
necessary.
Not necessary.
In place of social welfare, is there any other department required?
No.
Mr. A.R. Sikdar appears for the petition. MS P. Chakravarti, done it. Council, standing council, appears for the Department of Social Justice and Empowerment. Petitioner before this court is seeking a direction to the respondents to consider their case for selection and appointment in the remaining vacancies of about 155 posts yet to be filled up in pursuance to the advertisement, in pursuance to the selection and recruitment for 511 grade 4 posts reserved for persons with disability. Stop. Petitioners claim to be persons with disability. Benchmark disability.
Well,
Benchmark.
benchmark.
So there is no challenge made to the selected candidates. The limited prayer is that their cases should be considered, should be examined, and if possible, be considered for appointment in the remaining 155 vacant posts. MSP Chakravarti Lalat State Council submits that the selection was undertaken in 2018 and the appointments were made in 2022. Therefore, at this stage, no such direction can be issued, ought to be issued to the respondent. Then, the court is also prima facie of the view that the claim made by the petitioner does not appear to be maintainable as due to efflux of time, and also since there is no challenge made to the appointment of any of the other selected candidates. So, be that as it may, the prayer of the counsel for the petitioner that there is another petition pending being WPC number
562/2020.
562/22.
23.
Is submitted that the writ petition be listed along the same writ petition. Accordingly, this matter be listed along with WPC 5620
My lord, it was lastly listed on 5/6/5/20.
in the month of August.
Deep level.
Yes.
May I please, Your Lordship? One of the petitioner before Your Lordship is the assistant professor, the professor, serving before the Assam University Piku campus. Now, my lord, under challenge is the memorandum, the charge sheet dated 5/1/23 at page 52, issued by the respondent number 3. Now, my lord, the crux of the issue which led to the issuance of the charge sheet is that there were certain allegations of sexual harassment against one of my colleagues, one Dr. Aniruddha Kumar, which led to
The recommendations of the ICC. Since the petitioner submits that he be given a liberty to file an appeal under section 18. At this stage, the court considers it appropriate to dispose of the writ petition, permitting the petitioner to file an appeal within a period of 1 week. And
That's going to be 10 days.
Right, 10 days from today. Whereupon appellate authority will examine the matter and thereafter pass appropriate orders within 2 weeks. 2 weeks. Are you sure?
Yeah.
Then they have to call for the records, witness, everything.
Lordship, immediately if I appeal, proceeding will be started and if
Unless they are predetermined to dismiss it.
yes, my lord. No, Lordship. Immediately they have to consider all aspects of the.
They'll have to call for the records,
Lordship,
please.
it is up to the appellate authority, Lordship.
No, but let us give them 3 weeks at least.
If unnecessary, we will.
What we do is we will direct the appellate authority to expeditiously
Yes, yes, sir.
dispose of the appeal within the outer limit of 3 weeks.
Lordship.
The appellate authority will examine the matter and pass appropriate orders and on the appeal that the appeal, if preferred by the petitioner as per the liberty granted, as expeditiously as possible within a period of 3 weeks from today. Stop. Till such an order is passed and served on the petitioner, then we'll have to give a date. 3 weeks from today, which will be
Sixth of July. So this holiday, vacation. No, Lordship, before ICC probably it is not. Our High Court is closed.
within the outer limit of 7th of July,
First. 2026.
Needless to say, any such order that is passed, copies thereof shall be served on the petitioner. It is also directed that the appellate authority will give adequate opportunity of hearing to the writ petitioner. Stop. The writ petitioner in his turn will also present himself before the appellate authority and participate in the hearing that is permitted to be conducted. In such dates, which is 7th of July, proceedings initiated against the writ petitioner by show cause notice dated
5/1/26.
5/1/2026 shall not be proceeded with effect from today.
The writ petition may be listed
Writ-
for.
We are disposing it of. Writ petition closed. What for is the writ petition? The only
Lordship,
challenge is that it is on the basis of the ICC report.
Lordship,
We have already explained that at
Since-
this stage, we would not like to interfere with the proceeding. So let him complete. If the ICC gives the report in his finding, he'll present it and then see what.
Yes, sir.
Dispose.
Very good. Obliged.
Mister? What is this email? Somebody has sent an email?
Yes, Lordship, this is we have to submit for the inquiry officer. Visiting officer has been appointed in the.
That we have already stated.
Yes,
Inquiry
sir.
officer presenting officer.
That's why we have.
Alright.
I look at.
MS so and so. You give your names to the court master. Yes.
Item number 6 and 11 will be taken together. The petition and the scene.
11 also. Yes.
My lord, I would like, my lord, to take up 11 rather than 6. I would like to take up the 11, item number 11 matter.
11.
My lord, the petitioner here is an ACS officer of the batch of 2019. And my lord, at page 52 on 6/6/2023, my lord. My lord, some ACS officers were borrowed and were given or were deputed in the Department of Revenue and Disaster Management, including the petitioner as circle officer. My lord, his name is at serial number 10, my lord. Hiramoni Mili. Thereafter, my lord, he was posted in Udalguri.
So what is item 11? Essentially, you are challenging.
My lord, what I'm challenging is my transfer order. It was while the BTC election was ongoing.
they had transferred me. That is illegal. And second, they had transferred me against an unsanctioned post. An ACS officer against an unsanctioned post. I gave an application to the authority. My representation was pending.
So 52 is the order by which you were transferred
Yes,
to
yes,
BTC.
my lord.
You were transferred to BTC.
No, 52 is the order where, my lord, all these officers from the personal department was deputed to the revenue department, and from there, their revenue department borrowed us. That is the order for whole. Thereafter, my lord, the order where I was being transferred is at page 70, Annex 11. So my lord may see at second line, Sri Hiramuni Mili, that's a petitioner here, presently working as Circle Officer Udalguri Revenue Circle, is transferred and posted as Assistant DLR of BTC Kokrajhar. And thereafter, my lord, I gave a representation, that is at page 71, that this post is of unsanctioned post, and therefore I cannot, it's not clear where, my lord, application is at page 783, page 83, Annex 19. 83, Annex 19.
Yes.
This I have written to the secretary. With due respect, I have the honor that I, so and so, Udalguri, had availed earned leave, which was initially applied for a period of 4/8/29 and subsequently applied for extension up to so and so. On recommendation of earned leave, my recommending authority and in pursuance of letter number so and so, I had handed over the charge to Sri Montoos Chakraborty on the ground of the incumbent proceeding on earned leave. I beg to inform you that on the expiry of the said leave, I have resumed my duties in the office of the Circle Officer Udalguri. Accordingly, upon my resumption of duties, Sri Monto Chakraborty ALRS was holding the charge during the absence, is hereby relieved of the charge of officer with effect from so and so until further orders. Further, I have received the transfer and posting order posting me as Assistant Director of Land Records. I have honor to submit a representing the circumstances leading to my non-joining of the new place of posting and my resumption of duty at the office of Circle Officer Udalguri. Upon verification of records and establishment status, it is ascertained that the post of ADLR BTC Kokrajhar has not been duly sanctioned by the Department of Personnel, Government of Assam, nor accepted by Office of the Accountant General Assam. As such, is not financially sanctioned. As per FR 9/22/11 of the Assam Fundamental Subsidiary Rules, an officer transferred to a post must be duly sanctioned post carrying a definite rate of pay. Transfer of post without financial sanction would be irregular and render the drawal of so and so. And then, my lord, at end, I have stated that at page 84 that I most respectfully request the competent authority may kindly take note of my joining on 16/10/2025 and consider the keep the transfer posting order in abeyance till the issuance of further order of regulation of post ADLR in consultation with Department of Personnel, Government of Assam, and subsequent acceptance of Office of the Accountant General as will be deemed appropriate. The Secretary, Land and Revenue BTC did not do anything, my lord. Thereafter, I did not have any other choice, but then I wrote to the Additional Chief Secretary to the Government of Assam on 7/11/2025 for rectifying this error, because I was not able to join to my post, Circle Officer, nor I was able to join to the transfer post because that was a non-sanctioned post. I wrote on page 91 to the commission, to the Additional Chief Secretary, Government of Assam. Before that, my lord, I would like to take to page 90.
So what is your prayer in the writ petition?
My prayer, my writ petition is that, my lord, what has happened is that I, being a Circle Officer of ACS officer, I was transferred to a non-sanctioned post, which I gave a representation I cannot join because that's
when was the transfer dated?
My lord, the transfer was dated it was 24th July 2025. 24th July 2025. Now, interestingly, my lord, what has happened is that while this matter was, while my representation was pending before the Government of Assam, My lord, I would like to take to my new writ petition. That is at page, yes, my lord. There is an interesting fact because now my cause of action has changed. That's why I have had to file two writ petition. Now, my lord may see 3059 of 2026. Now let's see what the government of Assam, my original department has given me my thing. My lord, at page 23, annexure 1, my lord.
Yes.
In the interest of public service, Hiramoni Mili ACS Officer Circle Officer Udalguri Revenue Circle is hereby transferred as posted as Circle Officer Barkhetri Revenue Circle Nalbari versus existent vacant post. As per the government of Assam records and as per my personal department, I am still the Circle Officer in Assam. I was still the Circle Officer of Udalguri on till this notification was issued for me of transfer. Whereas in my earlier writ petition, which I have showed, my lord, they have transferred me to a non-sanctioned post. So how can a person, an officer, this was on 7/3/2026, just before the election. So my lord, in my first writ petition, because I did not join that non-sanctioned post, the borrowing department starts a DP, issues me a show cause notice saying that a DP will be proceeded against you. In my second writ petition, my representation was pending before my authority, my own department states that yes, you are Circle Officer Udalguri. So for the last 6 months, the BTC has been not giving me, has not asked me to, has keeping me lingering. Neither they have asked me to, neither they have.
But why have you filed the second writ petition?
Because, my lord, the second writ petition I have filed is because at annexure 3, page 40, my pay till today, I cannot be, all my pay slip of transfer order issues have not been issued because of the private respondent who's sitting there. And
Where?
In Udalguri. Because of the order which was at my earlier writ petition at page 70. And because of that, even though I have joined at my new posting, I have not been getting any pay or nothing. That is why my two writ petition I had to file.
Who is the respondent who will clarify what is going on?
In the first matter, Lotli Malala BTC, Malala is the master. There is the Malala contact. But because Malala, earlier he was serving as the under the BTC. Malala, he was the BTC on Malala. Thereafter, Malala, he was transferred to the. In the petition, Malala, there were nothing have been mentioned when he has been Malala joined in the service, Malala in the BTC or Malala he was.
No, it is there.
He was on leave lordship on that time.
It was there. Lordship.
And even then,
What is your prayer in the second writ petition?
My second
writ petition, Lordship, may kindly see the pair of the Malala.
So we come, let us, the first means which one? The 3059.
My lord, my lord may take the item number 11 one.
No, first you come to 3059 and tell us what is your prayer.
My lord, here my prayer is my regulation of my service, my lord. From the day, because of the transfer order which they've given for me to an unsanctioned post, from that day till the March 2026 order, I have been in lingering. So even though officially I have in a post, but I have not been given a sitting job. So that period has to be regularized by the department, and my salary has to be released.
And what is your prayer in that item 11?
Here, my lord, I'm challenging the transfer order and the proceeding.
Which transfer order?
The illegal transfer order, my lord, that is page 70.
Page 70.
Yes, my lord.
Yes.
See, Hiramoni Mili, ACS officer working as CEO Udalguri, is transferred and posted as assistant DLR of BTC Kokrajhar. So this order I'm challenging because this is a non-sanctioned post and this transfer order cannot happen. And I was not able to join this post because it's an unsanctioned post. Whereas as per the government official record, which I showed you in my in the other writ petition, the government of Assam, my parent department still constitute me for my earlier posting. And my lord, page 90, My lord may just see once. In person, may I read, my lord? In pursuance of secretarial letter.
All right, BTC, get your instructions. Get your instructions. Then Mr. Hendik, anything you want to submit?
My lord, in the first matter, my lord, he was, my lord, the direction to the regular.
First matter is nothing but it is the sequel to the
Yes, my lord.
Second,
item 11. The second matter, what is this item number?
11.
11.
No, not 11.
6. Yes, my lord.
Is the sequel of item 11.
Yes. Because, my lord, when this matter was pending and for listing, this happened. So I could not have, I had to file a new writ petition.
You're not challenging the transfer order.
No, I have challenged, my lord, in 3087. I am not, my lord, I am
No,
not.
Not 3087. The subsequent writ petition,
Yes.
you're not challenging the subsequent.
I don't need, because, my lord, from the, I have already joined here. I've already joined here.
Where?
In the new place of posting. So when I join my new place of posting, the AG gives me a letter that you please submit your earlier transfer order and your pay slip.
That's what we are saying.
Yes.
There is no challenge to the transfer order. You're not aggrieved by the
No,
subsequent.
I'm not agreed by transfer order here, madam.
You're aggrieved by the fact that whatever you stated in the earlier writ petition,
Yes.
that this is a non-sanctioned post or whatever,
Yes.
because of which you're not getting your pay slips.
Yes. And that has been rectified by the government itself on my second writ petition. Yes, I should be circle officer of.
Yes, get your instructions. Heard counsel for party issue notice. Both the writ petition. Returnable 4 weeks. Mr. J. Hendik appears for Revenue Department.
Respondent 4 only.
Respondent 4, Mr. J.K. Goswami appears for respondent number
6.
For Personal Department, and Mr. Musari for Orolan. Who is for Election Commission? Mr. Dubey are Dubey for Election Commission.
In item 6, I appear for the 8.
Since the respondent 1 to 6 in the item number 11 are represented, notices of which the extra copy will be furnished within a period of 1 week from today. Steps on respondent 7 by speed post within 1 week from today. Item 7, issue notice returnable 4 weeks. And Mr. J.K. Goswami appears for respondent number 1 and 2 and 3. Mr. Hendik for 4.
I'm for in item 11 3.
No, we are now in item 6.
6 is 4.
4 and Mr. Chakraborty for 5 and Mr. Musari for 6. And steps on respondent 7 by speed post within 1 week. Both matters returnable on the same day.
My lord, something with regard to my pay. I have been without pay. I have been still working.
Pendency of the writ petition will not be a bar for the respondents to ameliorate the grievances of the writ petitioner regarding his pay.
Much of.
Also, in this matter, the Department of Women and Child Development issued advertisement for filling up the vacant post of workers and helpers in different projects under the BTC. Accordingly, on 31/2025, the selection Viva was conducted and the select list was prepared. And thereafter, for this Gamgama ICDS project, the select list was sent to the respondent number 2, Joint Director.
Yes, instructions.
Notice made.
You want us to issue notice? You just get instructions. Why you've not given it? Why notice? Right, Mr. I. Ahmed, learned counsel for the petition, Mr. Mutari for the BTC, Mr. Chakraborty appearing for respondent number 1, and Musari for 2, 3, 4, 5, and 6. Grievance of the petitioner is that although being selected as what? Anganwadi worker.
Worker helpers.
So how many petitioners?
There are 60 pips.
Okay. Petitioners being selected as Anganwadi workers and helpers. Respect of Dhamnama ICDS project.
Yes.
The appointment orders have not been issued. The Gauhati counsel for the respondents will obtain their instructions as to the claims made by the writ petitioner. Although notices are not issued, extra copies be furnished within 3 working days. Matter be listed immediately on 15th of July. 15th of July.
What about observation will be made the pendency shall not be.
Pendency of the writ petition shall not be a bar. Issue the appointment orders as prayed for.
Matter regarding this and hardship.
Risk and hardship.
Yes,
Third council
Yes,
party
83.
notice. Page number 83. Notice and stay.
Must.
Yes.
The second round of litigation, earlier I filed as per the Upendra sir. Come as per this Upendra sir. As the judge. This is the settled law,
We should notice today. What else?
The PTC authority is preparing a list of the casual worker. These petitioner are the left out.
To examine this now. Because Jagjit Singh is not only about
Equal pay.
equal pay. Equal pay means you'll have to demonstrate that you are doing equal job. Not for the asking. Third council for party issue notice returnable 4 weeks. For forest, Mr.
S. Sharma for respondent.
H. Sharma for respondent number 1, 2. 1 and 2. Anyone for finance? Mr. P. Nayak for finance. Then Mushari for 4, 5, 6 also.
6 also.
7,
7 also.
8, 9. Since the respondent, the representative notices are waived, extra copies will be furnished within a period of 1 week.
Only my prayer, pending disposal of the which may not be part
Pendency of the writ petition shall not be a bar.
for consideration of the
Redress the claims made by the writ petition.
evening.
Yes,
May I
Mr. Sharma.
It is regarding restricting to
Gratuity.
gratuity. Supreme Court has tried to absolutely give clearance in your lordship page 66.
You're serving under.
Assam Financial Corporation. The Supreme
They have adopted the rules.
they have said that we will pay the gratuity at the parity of the Government of Assam notification. Government of Assam fixed at 15 lakhs. That has been clarified by the Honorable Supreme Court, page 66, your lordship.
All right, let's think that. We issue notice for today.
Yes.
Heard Mr. B. Sharma, Learned Counsel. Issue notice returnable 4 weeks. MSS Sharma appears for respondent number 1. Only 1. Mr. H. Alia for respondent number 2. Financial corporation?
For finance.
Not for corporation. For respondent number 2. Steps on respondents 3, 4, 5, 6, 7 by speed post within 1 week from today. Since the respondents 1 and 2 are represented, no formal notices be issued. However, extra copies will be furnished within a period of 1 week from today. Released after the returnable date.
The matter regarding my lord, selection and appointment of Anganabadi health worker. In this case, my lord, an advertisement was issued, my lord, on my lord, 1/11/2024, and along with that, my lord, advertisement, and some terms and conditions was my lord put there, my lord, and in Roshini can come to page, my lord, 19, the service version, my lord.
Yes.
Serial number 2, দুর্বল স্বাস্থ্য আৰু সংকটজনক ব্যাধি থকা হলে আবেদন নাকচ কৰা হ'ব। And my lord, the response number 5, she has been suffering cancer, my lord. And in this regard, my lord, the complaint was made, my lord, but no action was taken. Their interview was held. Subsequently, my lord, she produced and medical certificates. That is, your lordship may kindly turn to face, my lord, 35 minutes. That certificate was issued by a Dr. Milota, Medical and Health Officer, Civil Hospital, Golpara, stating that Milota, she is free from deafness, defective vision, including color vision, or any other infirmity, mental or physical, likely to interfere with the efficiency of her work and found her possessing good health. My summary lordship, Milota, go Milota.
How did you come to know she is suffering from the disease?
No, within the village, Milota, because Milota, Anganabadi helper, Milota, within the Anganabadi center, she is Milota. Particular area, within the short campus.
It is not your case that this is a false claim of suffering from the disease. You know that she is suffering.
Yes, my lord. And my lord, I have had my lord,
On humanitarian grounds, she deserves the job more than you do. No.
No, my lord. Otherwise, my lord, I am also eligible, my lord.
We are not questioning you. Mr.
Ballot medical certificate, ballot shows he is a fit person.
Now you obtain instructions. Then
I
also.
will obtain instruction, but
But if your allegation that she is suffering from that particular disease,
Well,
what is the basis? Because the medical report doesn't reflect anything.
yes.
That is so many.
At your instance, why should the person be subjected to a specific
No,
review?
my lord, but only better people lordship, that is page 37, my lord. I have already filed an application before the my lord, director to my lord, examine her from by the my lord, expert doctor, also medical board. That is page 37. That also may can be my lord, consider disposed of within the immediate period. Page 37, my lord.
This is absolutely bad taste.
But, my lord,
It is absolutely in bad taste. I know you are desperate for a job, but you are now asking somebody to go and get examined by an oncologist because you know that she is suffering from oncology. The report does not say that reflected, and you want an order from the court. You show us some report.
But Malata, however, Malata, so Malata, that representation was filed before the director. That
The director may file. What will the director do? Why should the director fix a medical board comprising of oncologists merely because you say so? You give some collateral evidence to show that she may not be able to perform the job.
Yes.
and since Malata, Anganabadi center, Lordship, that Malata, this Malata within a particular area.
Your knowledge is not sufficient to issue a writ. You are asking for a writ only on your knowledge without any collateral evidence.
And before Malata interview, we file complaint. That also Malata not considered. For the CDO, that is page 29. And
You file some collateral evidence and then we'll see. You have only on the basis of your representation, what direction will the court give to the director in terms of your disposal? He is going to catch hold of the private respondent and send her to an oncologist. That would be violation of human rights.
It is also not selected candidate.
No, select list is not published.
Then,
Select list is not published.
then you wait for the select list to be published. Why are you apprehending that you will not be selected?
Because Malata,
How many candidates? You and the private respondent.
no, Malata, there are some other candidates.
Then,
Some-
then
But notice may be issued, then Malata, pendency shall not be permanent.
I am not substantial evidence here.
being persuaded to, I cannot persuade myself to issue notice on it. How can that be? Get instructions if any.
Your body structure I will obtain, but only his statement is there. He is suffering from disease. Maybe disease, but cancer accident may be cured, and he can assume office, and he can run the office and affairs of the office. But only his allegation that
We'll say that the results of the selection be declared as expeditiously as possible, that we can say. And
Oh, yes, well,
Already consider मतलब हजार मतलब the
what would
because मतलब the
on what basis? Let me give a hypothetical example. Tomorrow somebody makes an allegation that Mr. Qayyum is not fit to appear in the court because he's suffering from so and so. Is it open to the person to get an order from the court that please direct Mr. Qayyum to present himself before the medical board?
it has to be examined.
Then some collateral evidence you have to give, say that notwithstanding the, see, she may, Mr. Sutia is correct that notwithstanding the disease that she may have been suffering and you could be right, she may be competent to hold, may not obstruct her in performance of her duty. You make that assessment.
But since selection has not been bad, that has to be examined by the authority.
That will be examined. As on date, select list has not been published. You don't know, you may be selected.
So I have already funded highly reclamation before the authority 145 million. That has to be considered.
Third counsel for the parties. The petition is filed by the petitioner, agreed that the representation preferred before the authority. But which representation?
Page 37 million.
Dated 4/5/2026, making allegations against the private respondent. Number 5, that she is suffering from acute or chronic diseases and would therefore render herself unfit for the job. Stop. It is submitted that the representation has not been disposed of and accordingly it is filed. So, the petitioner is also the private respondent and other similarly situated candidates had presented themselves for selection and appointment to the post of Anganwadi worker and helper. Helper. Bordol, Kalapani, bracket Nayapara, bracket close, Anganwadi center. Which district? Walpara.
Yes, CDPO
Under the Lokipur ICDS project in the district of Walpara. Stop. As on date, the results have not been declared, but the counsel for the petitioner submits that she has been informed that the petitioner, respondent 5, suffers from a life-threatening disease and therefore would not be a suitable candidate for appointment in the event of a selection. Submits that direction be issued to dispose of the representation. Mr. Sutia, learned additional senior government advocate, on the other hand, submits that as on date, the results have not been declared. So, at this stage, no such direction be issued. Considering the submissions made and also considering the fact that the representation dated 4/5/26 is pending. State petition directing the respondent authorities to declare the results in respect of the selection and appointment of selection of the Anganwadi helpers in the so-and-so Anganwadi center under the Lokipur ICDS project. Stop. If, as per rules, proper medical examination are required to be undertaken by the selected candidates, then the director will ensure that such examinations are undertaken in respect of any such candidate that may be selected. Writ petition disposed.
In this case, the petitioner is the senior manager of some gas company, HR and admin department.
Allegation on the POSH.
But there is nothing sexual.
So at this stage, what is your prayer?
My prayer is that already they have awarded a penalty against me.
deducting 50,000 rupees from my salary, 25,000 per month.
You will go and appeal
There is no provision of appeal in there.
under the PROCEED.
In the
Post
award itself, they have mentioned that. In the last page.
Where is the award?
That is in Annexure F.
Page number?
That is in page 114.
Yes.
Page number 115, it stated that please note that any appeal may be preferred from this order shall be made according to the provisions of the Post Act 2013. No other appeal from this order shall be entertained by the management of HCA. And moreover, my lord, there is no element of sexuality there. No
There-
intention of
no,
sexuality.
we are asking you, there is a provision for an appeal. You should go and file an appeal.
And in the rules also it is not
It
there.
it is there, Post Act.
In their employees rules it is not there.
Need not be. They'll have to make arrangements because the post rules are, no, it's there in the Act itself, section 18.
Act is there.
Uh,
The act is there.
They'll have to, who's for the company? Who's for the, is there a standing council?
No. The AGC Executive Conduct and Discipline and Appeal Rules, that is annexure.
No, if it is not there, then they'll have to make provision because the Act says that there has to be an appellate forum, section 18.
And in annexure H, they have added one addendum to the AGC Executive Conduct and Discipline and Appeal Rules, where they have stated that in statutory compliance of section 17 and section 19, 1I of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, the following sub-rules are added with immediate effect to Rule 5 Misconduct of the AGC Executive's Conduct, Discipline and Appeal Rules 1985. Subclause 5.24. Any act, behavior or conduct by an employee amounting to sexual harassment as defined, established and interpreted as per Indian laws in force, including court precedents to any woman, whether or not such woman is an employee of AGCL or not. Subclause 5.25. Any employee entrusted with the duty to handle or deal with the complaints, inquiry, or any recommendations or actions to be taken under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 contravenes the provisions of section 16 of the said act. Such employee shall be liable for appropriate penalty. Only that has been added. And that too, when this complaint came up during the pendency of the complaint, they have made this addendum in their executive conduct and discipline.
But this is not an appeal. But Mr. B. Chaudhary, the counsel for the petition. Petitioner is agreed by the order. Award of penalty. This is the finding, page 114. ICC finding?
Yes.
This is the finding.
Yes.
By the finding and award of appeal, award of penalty by the ICC on the petitioner by order dated 5/5/26 on the basis of a complaint lodged by the complainant. The proceedings were initiated and the ICC ultimately awarded penalty by order dated 5/5/2026. So the counsel for the petitioner submits that the recital in the order itself reflects that but it says any appeal can be preferred, may be preferred.
Any appeal from this, no other appeal from this order shall be entertained by the manager.
No other, but it says any appeal that may be preferred shall be made according to the provisions of the Post Act.
But there is no forum.
He submits that although it is specified that any appeal that may be preferred from the order under the Post Act of 2013 is prescribed, the order itself. However, there is no provision There is no forum under the company enabling profiling the appeal as prescribed in the Rule 18 of the Post Act. Considering the submissions made and upon perusal of the provisions of the Post Act, it is clear that there is a forum for an appeal against any such orders that may have been passed by the ICC. Person is so there is the appeal is to be referred within a period of 90 days from the basis of recommendations. So that being the mandate of the statute, it is incumbent on the company to ensure that there should be a forum for an appeal by the aggrieved party. So at this stage, therefore, notice we issued the returnable respondent 1, 2, and 3. No notices issued on respondent 4 at this stage. The steps on respondent 1, 2, and 3 be undertaken by speed post within 1 week from today. Matter be released immediately after the reopening on 17th of July.
In the interim time, there is an interim pay also.
What is that?
That was my salary should not be, this amount should not be deducted. Already for the month of May, one amount has been deducted.
Any amount that is deducted in terms of the penalty order shall be subject to outcome of the subject to such orders as may be passed finally by the court. Yeah.
Chairing selection process, 6/2025. Challenge is primarily premised on the fact is though the advertisement says the selection process will be selection also, they have gone ahead with the recruitment process, which may be permissible as per the APSC also. However, the ratio to the post and the vacant post and the applicants call where 1:10 also. This also it gives a reasonable apprehension that there is lots of arbitrariness in the selection process. So kindly come to the advertisement which was issued.
Yes.
It's page 20 also, which was issued in 25th of April of 2025. So
Yeah.
kindly come to page 24. Though there is no selection process which was given in the advertisement, however, it notes points to note number 1. On the board also, the admission at all stages of selection in which they are
Page number 24.
Yes, Lord. Points to note. Point number 1. I'm reading the bold part. Bolded. The admission at all stages of the selection in which they are admitted by the commissioner is purely provisional and under scrutiny, subject to their satisfying prescribed eligibility conditions. If on verification at any time, on any stage before or after the screening examination or written test and interview, it is found they do not fulfill any eligibility condition, their candidature for the post services will be cancelled. Though it indicated there will be 2-tier selection process, the selection was carried out only by interview and viva voice. Also, will kindly come to page 27 also. That is the notification after 1 year which says the interview will be held on the dates were given for the interview also. Page 27 also is found. So issued on 16th of May also. So now, then we have participated and also will come to page 29. That is the list of all the candidates which will call for the interview. Page 29. The total persons which were called is 133. Now they have come and selected 13. The ratio that the vacant post was 13. Persons were called without any screening after the only on the basis of the application is 133. That is more than 1:10. And the selection process, advertisement says there will be 2-tier selection process. One will be no screening test was carried out. And
No, what? Where is the Where is the prescription regarding the selection process?
Lordship, not in the advertisement, but there is only indication with regard to that. Lordship will kindly come to page, very last page 38. In the advertisement, the APSC publishes how the process of the direct recruitment will be carried out. It says selection process of Assam Public Service Commission starts as soon as the commission issues advertisement as per the requisition received from the concerned appointing authorities of the state government. Selection process varies from service to service as per the provisions of concerned service rules. There are two types of selection procedures, namely written examination followed by interview based on the syllabus according to the service rules concerned. That is one. Second is the no interview, through interview only. However, if the number of candidates is very high in comparison to the number of posts, a screening test is conducted to minimize the number of candidates proportionately, which of course depends on the discretion of the commission. Now, Lordship, 13 posts, 133 applications. That is 1:10, Lordship. In all the commission which are in the government of India and UPSC, it is only 1:3. In fact, advertisement which were issued for the recruitment to other posts, APSC has come up with 1:3, Lordship. Lordship, that is the advertisement of 2024 and 25 for the combined competitive examination, Lordship. It also, Lordship, 1:3. But there is no explanation as to why 1:10% were called. There is no screening test was carried out. I've flagged it the ratios. These are two advertisements.
So what is your grievance? Because it is by way of interview.
Lots only interview and the number of candidates which were called for the vacancies is 13 and the number of persons which were called, the ratio 1:3 which is prescribed and also adopted by the commission has not been adopted. And also the advertisement says the recruitment will be two-tier logic. So one will be first by screening test. There's no screening test to all the applications which were all the applicants logic. All the applicants were
No, but what is your grievance?
the process of selection.
The process of selection is at page 38.
Yes, Lord.
So they have chosen the second process.
Yes, Lord.
Interview.
Lord.
Where required some screening process.
That was not adhered.
Oh.
And advertisement also indicates that there will be a screening test and interview.
How many posts are there? 13.
13.
And how many candidates?
133 accepted candidates. That is a.
Then?
Lordship, now they have carried out the recruitment process without the screening. And also, Lordship, they have done the interview.
What about the interview?
It was carried out.
Carried out.
Carried out. We are alleging that there is scope for arbitrariness that, because what is given by judgments of the Honorable Court also says that only interview cannot be a process of recruitment, Lordship. And that too, calling in so many, calling the number of people against the vacancies is very high, Lordship. There ought to have been some screening which was carried out. Because even if the marks are considered, it is the percentage of marks is almost entire marks is only decided on the interview, Lordship. And the post
And what is this that you're showing?
that is the advertisement issued for the combined competitive examination by the APSC. And the ratio adhered to for calling someone for the interview is 1 post, 3 applicants. Lordship. Only in this case, they have called more than 10% for 1 post. And only process, it is a post of medical officers in the Department of Labor Government of Assam.
Yes.
I'll take instruction, but there is a preliminary objection, my lord. No, that is not applicable, my lord. So there is separate rule for all departments.
Absolutely. They have
And ACS, my lord, ACS is coming different rules, my lord. And here, my lord, he appeared in the interview. He failed. Now he before this honorable court. The method of recruitment, my lord, that is, my lord, your lordship kindly see the document. Which is already submit, but it is clear that the discussion of the my lord commission, my lord. Because when there is a numbers of candidates high, then only screening test is required. 133 candidate, my lord, 4 days interview, my lord. There is a selection board.
But why selection is made only on the basis of interview?
That is, my lord, permitted by the rules.
What rules?
There are rules, my lord. There is a department rule there. If rules is there,
What is hospital is that?
no, this is not a hospital, my lord. It is
Labor Department.
the labor department.
You are not selected.
He appeared, my lord. He interviewed.
So then how do you again turn around and challenge the process now?
Lordship, because the process with the advertisement says, Lordship will kindly come back to the advertisement. It says there will be 2 tiers selection process. Lordship will come back to the page.
When did you come to know that there was no?
On the day of the interview, because there is nothing, no notification, nothing was issued, Lordship. Also, kindly come back to the advertisement.
Hmm.
Page 24. What we
Yes.
understand would be that point number one, if on verification at any time or any stage before or after screening, examination or written test. Now they use an interview. It is not or interview. And Lordship will kindly turn to page 26. Lordship will kindly turn to page 26.
Yes.
They say the direct recruitment, Lordship. They also states the selection procedure will be notified later on, followed by issuing corrigendum, addendum if required. Commission will decide the provision for selection in respect of any post-service services considering the status, cadre, grade, and number of applications. So number of application was something to be considered even for deciding by themselves or utilizing the discretion with regard to the process of selection. And this was on May 16, which was notified on 22 May. And selection process started from 26th of May. And everything was decided only on the basis of interview.
Get your instruction.
Fine.
Heard.
I'll get
Learned counsel for the party to issue notice. Then about 4 weeks, Mr. Imangal and its senior counsel, assisted by Mr. Sharma, appears. Yes, APSC. 1, 2 and 3.
2 and 3.
2 and 3. Mr. J.K. Goswami appears for respondent number 1. Steps on respondent 4 to 16.
Through APC.
No, you cannot, my lord. That is not the way.
Address may be provided.
How can I, my lord? Address you cannot provide, my lord. Your lordship kindly see after selection we have sent it to the government. We have no relation with them. So that department can.
Who is the government?
That is the
Labor.
Labor department.
So Labor Department, please furnish the addresses of 4 to 16 to the petitioner for undertaking steps. Or we direct them steps to be undertaken through you. So then we do one thing, the steps of respondent 4 to 16 to be undertaken through the respondent number 1, subject to payment of the necessary expenses for the steps to be undertaken by speed post. Right? That's right. So where are the posts? They have not joined. Then how do they serve the addresses? Mr. Monto, you have to give the addresses.
No, my lord, after giving my lord recommendation to the government, my lord, we have
no record.
My lord,
You must be having the records of these. Give the addresses.
document that is
Only the addresses. So that the notices can go.
that can be, my lord. Already we forwarded everything to the government, my lord. Government also, my lord. Because if it your lordship kind of
Are you submitting that the APSC has no record?
definitely they have a record, my lord.
So then give them.
But no, my lord, if your lordship, my lord, it will be very bad precedent, my lord. It will be we have to, my lord. I mean, so many candidates, 100, 200, 300 candidates, my lord, on always, my lord, they challenge before this honorable court. The government will, my lord, they already everything, my lord, along with their application also, my lord. We have a copy that is true, my lord.
Then we'll not issue notice on 4 and 16. Don't raise the objection that selected candidates are not informed. How will they be informed? If the addresses are not furnished, government doesn't have the address. That's what they say. They have not joined.
Not joined. Now it is up to them, my lord. They have joined or not, my lord. They will
The same thing whether it comes from the government or from the APSC.
No, APSC provide, my lord. Then again they have to take the troubles, my lord.
Take the trouble.
No, that will be a bad precedent in future, my lord. Your lordship
Then that precedent will be
No,
applicable.
what
to
I am
the
submitting, my
department
lord.
also.
Suppose in APSC selection, my lord.
What alternative suggestion you give?
No, that is it is his duty, my lord. That is it is everything. No, that is duty of the petitioner. It is a petitioner can be for honorable court. It is in online. Everything they will get, my lord. They will get everything in online, my lord.
Online where?
They will get, my lord. That government will. Here, my lord. Yes.
The applications are through whom? Through the department.
No one, yes.
No, no, it is APSC.
Direct.
Everything. The
Then
advertisement.
you furnish the address.
The advertisement.
You furnish the addresses to the petitioner.
If the court pass a order and mal, but it will be a bad precedent. That's why I'm
It will be a bad precedent, you correct it.
No,
by
I
another
don't,
good
your
precedent.
lordship
See,
always,
the question is that somebody is before the court, we have to examine it. We need not issue notice on the private respondent as on date because we are not convinced as yet.
my
that
lord,
We'll have to allow the writ
correct,
petition.
absolutely correct, my lord.
But then we don't want to hear an objection saying that the private respondents are not issued notice when the matter is ripe for hearing. So in order to remove all the matter is there before the court has to hear and pass some orders.
Definitely.
Now, in the absence of notices being issued to the private respondent, otherwise the matter gets
No, that is no problem,
elongated. The
no
only
problem
question
for
is
us, my lord.
getting
We
the
can-
addresses.
That is, record is with our application with our their addresses are with us, my lord. But my lord, already we recommend to the government. Government if already in posted, my lord, there somewhere is, my lord. That is up to the government take this, whether they have appointed. That is only on 2nd June it was done. We have forwarded to the government, 2nd
But you
June,
have forwarded the list of names. Does it contain
No,
the
that is-
addresses also?
name, my lord. No, then they will issue the appointment letter to the on their address, my lord.
As on date, they are not appointed. Right. Then notice at this stage in respondent number 4 to 16 are not issued as the Learned Government Council, Mr. J.K. Goswami, submits that appointment letters are not issued as on date. The such circumstances. Letter be posted after the returnable date, by which date the respondent will, or particularly respondent number 2 and 3, will address the court on the allegations, on the contentions made by the petitioner with regard
And regarding maintainability upon your lordship, keep open.
the counsel for the petitioner questions the maintainability of the writ petition is kept open to be
My lord.
addressed. The Learned Government Council is permitted to intimate the court and when the appointment orders are issued to the private respondent.
If the petition will be subject to outcome of the writ petition.
They are not even appointed.
Lordship. Appointment orders and issues.
They are not appointed.
Lordship, not
As on date.
like if
Lordship, I'm assailing a transfer order, my lord. The petitioner is a constable with the CRPF. The transfer order was issued long back in 22/12/2025. Against that, my lord, I had filed a representation which was rejected without any reason, my lords. Thereafter, well, I'm seeking personal interview with the DG, my lords.
You're seeking?
Personal interview with the DG, my lord. DG of
Why should the DG give you an interview?
my lords, so I can approach him, my lord, and
If permitted under the rules, then yes. Otherwise, no.
that has been left unattended. Thereafter, my lords, my only ground, I have two grounds. I won't press on another. My mother is suffering from cancer, going through chemotherapy. And another one, my
Where
mother,
are you transferred from?
I'm transferred from Gauhati to Jammu and Kashmir, my lords. I have
Jammu
a,
and Kashmir.
my lords,
You are
my
serving as what?
head
CRPF.
constable, my lords, CRPF.
CRPF.
I have a daughter, my lords, who is pursuing, is in class 12 right now, my lords. Midst of academic session, my lords, I pray
These
for
are what can be done now?
I can, my
A
lords,
member of the services.
I understand, but 1 year retention if they consider till
But
the
they
academic
have
session is over,
rejected-
my lords.
Rejected.
They have rejected your
Then
application.
rejected, my lord, rejection, my lord, see no cogent reason or nothing, my lord. Simply said a rejection, rejected.
It's not necessary, Lordship. They have
No, my lord, it
considered
is necessary. Every reason, every order passed by the administrative authorities has to be a speaking order, my lord.
This is reflected in the portal.
My lord,
Rejection order is at page 28.
28, my lord. It's 28. It's but not by the software, it's by the DIG, my lord.
The application is to whom?
My lord, I applied to the DIG, my lord, at page 25.
Oh.
My lord, is translated. Originally is at 27. Referred to 23/12. this area of 24 years, I have never sought any kind of. I've complied by the whatever transfer order he has given, my lord. The authorities have passed, but this time I have a dire straits. My mother is 70-year-old, my lord, and my daughter is staying with me at my quarter and preparing for NEET. That's true.
What can be done?
I have a small judgment if lordship is inclined to look into. This judgment, though very brief and short, my lord, has deprecated, my lord, the transfer of authorities or transfers in the midst of academic session.
Go before the tribunal.
My lord,
It's not a judgment, it's an order.
well, it has been reported, so I
Reported order.
but it was disposed of. So
Not to
appeal is
talk about that, it is
it
not
was an appeal
binding.
from the CAT, my lord. The appeal is allowed accordingly to.
This
Final order.
is this regarding CRPF?
No, my lord.
Then
But normally, my lord, it has.
this is the chain transfer.
Yes, sir. I understand.
So you know that in this particular period of time, there will be chain transfers.
Chain transfer.
And this is not a case of in the middle of the academic term.
It's my lord, it's a case of academic.
How?
Term, my lord. My daughter is studying at 12, my lord.
Now, starting at 12,
12,
see the
I have
period.
annexed, my lord, the document.
Is there any rule to say that these cases are to be exempted? There is a set of rules.
Not exactly, my lord.
Yeah.
But page 38, my lord. I have an identity card of the daughter, my lord.
So come to page 43, the exemptions. Medical
43, my lord,
grounds.
medical grounds, I don't,
Autistic,
I'm not pressing
approved.
because my mother is out of this.
Terminal postings.
No, my lord, that is regarding
This is
your
not
person who is
applicable.
retired in 2 years, my lord.
This is the transfer guideline he annexed for all kind of transfer.
This has to be annexed because, my lord, this is the guideline covering the issue. So I cannot be, I have to be fair, my lord. Otherwise, my lord, at page 43, what you can see there's a category of compassionate / administrative transfer, my lord. They have to, some element of compassion should be there, my lord. Their own guideline is there.
Where is that representation which was rejected?
My lord, it is page 25. Ask me what is pending, sir. I have provided some choice.
All right, you reconsider this application in terms of the guidelines.
That was considered guidelines where
The order doesn't reflect anything.
but lordship in all this kind of order lordship only that was reflected. It's not specifically not mentioned that it was there. But his case that lordship he is out of 2 ground. One is that but
Now,
he
see, we come to page number 43.
lordship.
The guideline says that (43) is for compassionate transfer.
No, my lord, that can be, that can have a another view of the matter, my lord, that they can, that whenever I'm seeking, my lords, because my representation says you can transfer me, but can you somehow place me in those battalions, my lords, accommodate me in those battalions, my lords. As plain and simple reading, it seems like okay, I want to be transferred out, but my lord, that the very its content therein, my lord, that whenever I resist my transfer also have to be given a considerate.
Lordship, I have verbal instruction that already he is relieved lordship. 10th on 10/6/2006 relief order has been issued. Order is on my file also, Lordship. And this order of first order was of 22/12/2025. The first transfer order. Let us take it that he was waiting for his representation to be disposed of. That was on 10/2/2026. So for more than 4 months, he waited till the last time. Now, when after his he filed it on 9/6 and 10/6, his order was issued. Relief order was issued. Those cases, all those SCT were stayed up to 15th of May, Lordship, because of the election. All the other similarly situated persons, they had filed, some orders were allowed, some were disposed of. But now at the belated stage.
That in that case, I have to again press to the rejection part, because some other cases which I am holding, my lords, the court has called for records. That when you reject, you say the board of officers have said. Where is the element that you have?
Where is the rejection order?
28 minutes.
And he had only annexed one identity card. And I have Google Lordship, this PNC Academy, it has a residential school. And it is only for those competitive examination. He is
21.
28 minutes. Those cases, for those category of cases, this document is there, but court is not satisfied. They are asked to bring records.
After considering all aspects, admin option requirement of the force, so this has been done, Lordship. And this is of 10/2/2026. And he knows that his daughter is studying. Not now, Lordship.
Thereafter, 16/5/26. The mother stays at Gorpeta with his wife. She's taking chemotherapy, and daughter stays in Gauhati with the father.
How many daughters have you got?
Two.
Two. So both
One
the
is a-
daughters are with you.
One elder daughter is with me.
But this is not a ground for transfer.
This is a residential school, Lordship.
It would be a ground for transfer that you are preparing for NEET.
Well, I just need retention, man. If they can consider me, man, that's all.
The NEET exams, she's appearing next year.
Yes, Lord.
Next, she's nobody's to look after her, man, here, because mother is suffering from cancer, taking chemotherapy, man. I have
Not mother, grandmother. Petitioner's
Petitioner's
mother.
mother. Petitioner's mother.
Petitioner's mother.
And this school, as I have put it, Lordship, it has a residential
This
school.
cannot be a ground unless you show us any precedent or any grounds. They have
In that
considered
case,
and
my lord,
rejected.
in that case, I'll again fall back to that annexure, annexure 428. When you reject, my lord, where are the reasoning, my lord?
Annexure
For rejection order 28, my lord. Where is the
must be
reason?
available in the file. The
Because
record.
no, my lord, I have come through a lot of cases like this, my lords. They are unable to produce anything which is
See, you are a
those
man
cases
of
lingering
discipline.
on.
You are a man of discipline services.
I understand, my lord,
But have you made a statement anywhere that this was summarily rejected and who not considered any statement here?
Yes, ma'am.
He had two grounds, Lordship. He had, in one ground, he himself has stated that his wife is the caregiver for his father. And for other reason, Lordship, that only the examination part. So what more is
at para 5, my
should
lords,
reflect in the order, Lordship?
I had said, my lord, simplicity rejection is there. I'm being transferred. And another, my lords, I have been 23. I was brought in from Chhattisgarh.
All right, you produce the record. That's
My
all we
lords.
can get.
My lords.
Get the record for rejection. Let us see.
Lordship. But Lordship, his application is that his daughter is for what more is
But
required,
you have
Lordship.
Page number 28, you rejected.
Yes, Lord.
Show us the record how it's considered rejected.
His application, there probably, I'm not sure, but probably there is no requirement, any other record. But that is his application, two grounds that one he
Then
himself
they'll have
has
to
stated.
give us reason why it was recorded.
Lordship, any office noting or etc.
Something like that. Let the records be produced in connection with the rejection of the representation by order dated 10/2026. Rejection of the representation of the petitioner by order dated 10/2026 by the respondent authorities. List on
Either Monday or Tuesday.
Tuesday 16th. All the extra copies we furnished to the
Right.
learner CGC during the course of the day.
Till
Okay.
then, my lord, status quo.
19 till 19, he had 9 days. From 10 to 19, he is
You were there till 19.
19. Yes,
16 will give.
Lordship.
All right.
This letter is also connected with the item 49, 50, item 49 and 50, 51. These are connected.
49, 50, 51.
Even Lordship 42 and 43 also connected matters. Their Lordship, we have
No,
five.
this is for motion.
Yes, Lordship.
Yes. The others are for admission.
Yes.
Then
Challenge Lordship.
what is the challenge here?
Challenge Lordship, there Lordship, one selected persons has been shown as the provisional selected Lordship.
Huh?
Without preparing any merit list Lordship.
Well, we issue notice here then.
Yes.
Third counsel for party issue notice. Mr. D. Upamanyu, learned standing counsel for
All the response.
Health Department, appears for all the respondents. Therefore, notice is the way the extra copy is furnished within a period of 1 week from today. Released after the returnable date.
Highly.
Yes. What was required to be?
On last date, Lordship directed me to produce the list, Lordship. The original list wherein the finance department given approval, wherein the name of the petitioners were not there. Lordship, I found that that document is already before your Lordship in an affidavit filed by the IWD Lordship. That is in WPC number 1. WPC number 4759/2007 in the earlier case, Lord. I may furnish a copy of that list, Lord.
This is not a part of the pleadings.
Not of the present pleading, Lord. But if that file is called Lordship, then it will be there.
Let us.
Yes, what is that?
Irrespective of the approval, even if there is no approval, still they are entitled to the benefit.
That is not your prayer here.
Yes,
Well, your prayer is that you are already confirmed.
yes.
And your salary, pension, whatever is to be done has to be given. You are asking for area salary.
Salary which from regularization. Regulation,
Which according to them, you are not entitled because you are not in.
regulation order is there.
No, from that early date.
From the early date also they have regularized my service. They made a plea that that regulation order was later on recalled. That recall order was never produced before the court nor served upon the petitioners. Just serving those orders, that order cannot be even effective.
Lordship, it starts from page 88, that is Hailakandi district. Lordship, may kindly see the seal there of the finance department.
No, what is this list? It's a part of what list?
This is the original approved list by the finance department as well as by the cabinet. And if from page 88, Lordship may kindly see it is Hailakandi district, first column under IWD. Lordship, in this list, Lordship, petitioners' names were not there. That is the first list, Lordship. And if Lordship comes to page 95,
88.
Hailakandi starts from 88, IWP, Hailakandi.
Then
Then if Lordship comes to page 95, Lordship, this is the list prepared by the director IWP.
95.
Yes. That is an Excel tree.
It contains the name of the petitioners.
Yeah, yes. Lord. And Lordship will find, Lordship, in this letter, nowhere it is mentioned that these names were approved by the finance department.
But there is a reference that is issues in concurrence of the finance department.
That is the manipulation. And on the basis of this manipulation only, subsequently finance department directed the transport department to take action against the officers, Lordship, and subsequently actions has also been taken.
So is there any letter of 22805 of the finance department? Page number 95.
211005.
22805. You come to page number 95.
Yes.
Serial number 2. Subpara, it says that this issues and concurrence of so and so, ID letter number so and so. Is there any letter of the finance department by this date and number?
That initial number, Lordship, may kindly see the second line. White gov letter number so and so dated 2110-2005. This is the original approval list. That 23rd line, 2110-2005.
You are reading from page number 95.
Page number 95 from the beginning, third line, Lordship.
Third line.
2110. This is the original approved list. Although it is mentioned that
710.
Lordship is page 95.
No, page 95, there is a reference initially of the letter 2110-2005.
That is the approved list.
Now, this approved list which you are showing,
yes,
is dated 7th of October 2005.
Lordship, no, this is the finance approved list. Subsequently, it was signed by the Secretary Transport Department. I think the second list, Lordship. The Lordship, that is page 9, I think. Page 9, Lordship. Page 9.
Yes.
Not at the top, Lordship.
7th October.
7th October. So this is the original approved list. In this list, the name of the petitioners were not there. But however, the director IWT manipulated the list, and by saying that their names were there.
No, we understand that. But you come to page number 95, serial number 2, subpara.
Yes.
So, serial 2 says this post will not be filled up by any other person.
Yes, that is the condition.
So and so, and this issues as per concurrence of the finance department. Is there any letter of this nature, 22-8?
22-8 is the letter, Lordship, that was written by the finance department to 10 numbers of departments, Lordship. Original deliveries.
Yes. So page number 9 is the approved list as circulated by the additional chief secretary.
Transport department.
And it does not contain their names.
Yes.
Whereas this subsequent letter of 95,
yes,
which is dated 2110.
2110-2005.
2005.
It is not by the government, but by the director. This is not because of any spelling mistake or anything like that, Lord.
It was filed in the earlier of the litigation. So should we kindly record the order passing the earlier of the litigation, the finding of the Supreme Court.
Where is that order?
That order Lordship by that page.
That 2007
59.
order, Lord.
Page 59. This affidavit was considered. That was the pleadings made in this petition, my lord. Page 59. This pleading, this is the finding of this room. Page 59. That was filed in this petition only, my lord. 759.
That was not my purpose to show this, produce this record, Lordship. My purpose is different. What I'm saying, Lordship, if Lordship comes to page 94 of this present writ petition, Lord.
1 minute. Now, in terms of this order at page 60, 59 or 60, there was a submission recorded that the matter is pending before the finance department and some approval is required to be given.
That is a subsequent proposal, Lordship. That is what I'm trying to say. If Lordship comes to page 94.
Of this bunch.
No, of the writ petition.
Writ petition.
Lordship, in 2005, one policy, Lordship. 2005, we regularized around 30,000. Now, this is dated 31st of October 2006. 31st of October 2006. This letter. Lordship, in this letter, all the departments were again instructed to send the name of the master and works as employees whose names were left in the first round, Lordship. And pursuant to this notification, the petitioners' names were forwarded to the finance department.
Not what is recorded.
No, Lordship, that is a judgment of 2007.
7 judgment doesn't say it's.
And their names were forwarded at page 53, Lordship.
Of the writ petition.
Yes, Lordship. Policy is at page 94, 2006 policy. At page 53, Lordship may kindly see. Lordship may kindly see the reference, 31st October 2006.
You're reading from page?
Page 53, Lordship.
53.
Lordship may kindly see the reference. This is this letter, 31st of October 2006. This is page 94.
Yes.
Lordship, pursuant to this letter dated 31st of October 2006, petitioners' names were forwarded. Next page, Lordship may kindly see the names were there. Names are there.
Yes.
This is Samanuddin is there. Ataur Rahman is there. Noor Ali is there. Jaharuddin is there. Next page, Lordship.
And how many petitioners?
5, Lordship. All the petitioners are there.
And the Ashikuddin.
Asikuddin is the first one, Lordship. Lordship may start from 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. From 11 lots.
Yes.
Asikuddin 11, 12 Samanuddin, Ataur Rahman. So their names were forwarded in the year 2006 pursuant to the Finance Department's letter dated 31st October 2006. So their names were not there in the first place for whatever reason. It was forwarded only in terms of 31st October 2006 and it was forwarded on 29th October 2006. So this issue was pending before the Finance Department, and that is why it was the apprehension of the petitioner that if that OM of 2012 is given effect, then their services will never be regularized. That was their apprehension, and that is why in this writ petition they challenged that notification of 2012. Lordship, if it comes to the prayer, Lordship, that is the first prayer. So statement wise and pleading wise, Lordship, this is the case, Lordship. Earlier round, there was definitely a direction, review petition file, but in this petition, Lordship, it was basically that apprehension that if this office memorandum of 16 June 2012 is given effect, then their services will never be considered for regularization. That was the fear, and that is why this writ petition was prepared.
Then this was appeal. Office memorandum.
Pendas Lordship, it was appeal. So that is why
So assuming this is set aside, then your claim would be only with effect from 29th of November 2006 at best.
My claim will relate back to 22/7/2005. Paragraph 79 of Suketi Bacharji says that all the left out master workers, they will be entitled to regularization with effect from 22/7/2005.
No, my friends would not mislead Lordship. Lordship will read the judgment. Lordship, that judgment applies only to the writ appellants. Only to the writ appellants.
Must kindly peruse the earlier round of litigation. That order neither reviewed nor set aside. That has attained finality. After that order, whether there is any scope to reappoint the issue man. That order has already attained finality.
All right. Third reserve.
So, Lordship, I have submission. To that extent, Lordship, I have nothing to say. This is the facts, Lord. If Lordship comes to the recent judgment, if he is relying upon the recent judgment,
To the appellants. Applicable to the appellants.
One. Second, Lordship, at best, he can rely upon this judgment as a precedent, Lordship. If that is done, Lordship, in that situation, Lordship, I will have my submission. Whether this particular judgment have any precedential value.
The Supreme Court judgment.
Lordship, I will place it.
Court judgment. So
No. Lordship will bear with me. I'm reading at this stage, Lordship will consider this case. And we are also going through the judgment passed by the Supreme Court, Lordship. But what is our primary assessment, Lordship? I'm submitting on that basis, Lordship. I'm reading a very small paragraph of Uma Devi, Lordship. Paragraph 54. 3-line, Lordship, I'm reading. It is also clarified that those decisions which run counter to the principle settled in this decision or in which directions running counter to what we have held herein will stand denuded of their status as precedents.
As on the date of Uma Devi.
No, it is not said that judgment passed earlier or judgment that is going to be passed now. Any judgment.
You have made the submission, but will not record it. The reason being that the judgment cannot foresee what judgments are going to come in the future and say those judgments will not be with the judgment. Will be denuded of these.
But Lordship will at least accept the principle.
No, there's no principle there. It is only on the date when Uma Devi was passed.
Lordship.
The principle laid down in respect of by the other judgments, earlier judgments, prevalent at that time, which are in conflict with Uma Devi. Because Uma Devi is a 5 judges bench.
Lordship, it is, I'm submitting this as precedent, Lordship. Another decision I'm showing, Lordship.
No, you are submitting this as the precedent for what purpose? For which proposition?
Lordship, I am, in my understanding, Lordship, this present judgment is
Is in
absolutely
Are you saying that the present judgment is in conflict with Uma Devi and therefore it has not overruled Uma Devi, therefore it will go?
No, there is
Or
no,
are you saying that no, Uma Devi has said that any judgment not in conflict with, not in tune with Uma Devi will be denuded? For which part?
two citations, Lordship. My first submission, this present judgment runs counter to the principle laid down in Uma Devi, that is one.
No. Uma Devi is how many judges?
5 judges.
And this judgment is 2 judges. So
That
you
is
want to say that the binding precedent remains and this judgment will not be a binding precedent to that extent.
Yes.
Right.
And second judgment, Lordship, another judgment is there. Actually, another 3 lines, Lordship, paragraph 75. By virtue of Article 141 of the Constitution, the judgment of the Constitution Bench in State of Karnataka versus Uma Devi is binding on all the courts, including this court, till the same is overruled by the larger bench. That is my second. So my submission will remain. Yes, in case of the appellant's a judgment was passed, we'll deal with that judgment, Lordship, whatever manner is possible, Lordship, court will decide. But to rely upon that judgment as a precedent.
So you have not referred to the judgment to say that these are the paragraphs which are in conflict.
Supreme Court.
You have to refer to the paragraph that these findings are in conflict with the earlier judgment. Therefore, it is not a binding precedent.
Supreme Court is
Why are you blowing hot and cold? On one hand, you are saying this is not a binding precedent. On the other hand, you don't want to refer to.
Now I am saying, Lordship, this is not binding because of these judgments.
No. Which part is not binding? Which part in the judgment? Which paragraphs?
Lordship, the grounds, the reasons.
Not like that. You have to refer to the judgment. How can you make a omnibus
Lordship, that is why I am submitting at this stage. We are also now going through the judgment.
So, alright, go through, then we want to close it. We keep it on 23rd or 24th June. 2013 matter. How long do you want to carry it?
Lordship will take up this matter after vacation. In the meantime, Lordship, we are also contemplating to prepare a review before the Supreme Court.
Oh, you do whatever you want to do. Just have to tell us. We have to understand the judgment as it stands today. What is going to happen if you file a review, whether it will be taken note of, not, etc. is a different issue. But
and there is time is there because Lordship in the Supreme Court
thoroughly discussed in Sugandhi Bhattacharya. That has been interpreted by the Sugandhi Bhattacharya.
so if you want opportunity, we'll give you. Otherwise, we're closing it. We can read the judgment for ourselves. There's no problem on that. If we want an opportunity to persuade the court that no, this provision is not good or in conflict, etc., your principle, we have accepted it. And the 2013 matter.
I am not aware in what line Lordship is going to discuss.
Of course, you are not. Even delivery of the judgment that I'll be aware. Do you think we make up our minds by closing? No. We have to read and then find and decide the judgment. Decide for us.
In case Lordship relies upon this judgment passed by the
No, I have to. It is binding on us.
In that situation, I am praying for an opportunity for submitting.
Whatever is there in the judgment is there. We are also conscious of Uma Devi has not been interfered with. The judgment has not interfered with Uma Devi. The judgment did not say that Uma Devi is no longer a good law. So both will have to be juxtaposed and then decided as to what is the how the balances will tilt.
Lordship, why we are so serious about this issue. Consequence is going to be very huge. And Lordship will at least consider that consequence.
They can regularize 30,000 master workers, 3,000 lots are there.
Very serious.
So the question we have actually thought we'll deliberate, pronounce it, but there was some correction. So we can say that we are dismissing the petition. And the other side may be informed. We get the order.
I'm just making this mention because I thought if I need to address the court.
No, no, you're moving for passing.
Okay.
Lordship, we need some time to file the affidavit in reply.
Counsel for the petitioner renews the prayer for filing affidavit in reply, prayer made. Counsel submits the matter to listed after 4 weeks. Prayer made is not objected to by the respondent, list after 4 weeks.
If the service has been completed, all the respondents are served. The respondent number 3 has filed the reply and we have filed a rejoinder also. In this case, what has happened, I was a partner in a firm with respondent number 1, with the respondent number 3, with respondent number 2, sorry. Then I retired, then we executed and respondent number 2 was inducted. Respondent number 3 was inducted as a new partner.
There are only 2 respondents.
There are 3 respondents. One is the partnership firm.
Okay.
I'm 14.
Respondent number 3 is here. 2 has not appeared, though the service is complete. So then we executed a retirement cum admission deed. In that deed, in terms of the deed, the continuing partners were supposed to give me 15 lakhs as retirement benefits, which was not given. Thereafter, also in terms of the deed at clause number 7, the continuing partners were supposed to indemnify with all the debts and liabilities of the firm when I was associated with the firm. There were 2 loans which were extended to us during my tenure. My lords, what has happened, the one financial institution has already invoked arbitration in Delhi, making me a party also. My lord, I have retired from the firm. They had taken and given a promise that they'll repay the debt. But that was not done. Then demands were made, requests were made, requests and reminders were made, which was paid no heed. Then I had to finally send a legal notice, demand notice, which was also not responded. Then, my lords, I had to invoke the arbitration. There is an arbitration clause in terms of the deed.
Where is the subsequent deed?
Subsequent deed is, my lords, at page 28. It starts at page 28. This is a supplementary deed of partnership for admission cum retirement of partners. In Messrs. RK Associates, my lords, the obligation to pay is at clause 4 at page 30. Man. At page 7, they were supposed to pay the debt also, which was taken during my tenure, my association with the firm. So that was not done. So I'm before your lordship now, as they have not agreed for my nomination of arbitration also. The arbitration clause is at my lord page 38, clause 15.
Under the supplementary deed, you're claiming under supplementary deed.
My lords.
Which provision?
My lords, at clause 4, page 30. If I may read. My lords, at page 30, last clause, my lords, page 4, that the continuing partners are, my lords, respondent number 2 and 3. That the continuing partners agree to pay all debts and liabilities of the said firm
and to indemnify and keep indemnified the retiring partner, which is me, against all such debts and liabilities and all loss, cost, charges, and expenses that the retiring partner may incur or suffer on account thereof. Manoj, at clause 7 also, that after settled accounts of the assets, subject to the debts and liabilities and the profits earned till date have been made, that after settlement of accounts of the firm, namely Messrs. RK Associates, it is found that the retiring partner is entitled to an amount of 15 lakhs only from the firm, and as such, the continuing partners agree to pay the due amount of rupees 15 lakhs from the firm at 1% interest starting from first day of January 25 until the amount gets exhausted. So I was claiming this.
Lordship, in this regard, Lordship, I have already paid an amount of 8 lakhs, Lordship.
What is the claim of the petition?
Claim, my lords, they had to repay the debts also. There is an arbitration going on in Delhi.
One loan also already closed, Lordship.
The financial institutions have initiated arbitration petitions against me and the firm also, which they were supposed to
Indemnify.
in terms of this clause, and the 15 lakhs which I am supposed to get under clause 7 of this agreement. That is admitted, my lords. They have filed a reply. They have said that they have given me 8 lakhs rupees, but that is towards a different transaction. So there is clearly a differential dispute which is arising. I am praying for an appointment of the sole arbitrator in this.
Where is the notice under 21?
21, my lord, is at page 57.
7.
My lord, I'm sorry. It's 55, my lord. It starts at 55. Annexure 5. Thirty-one 1/2026. Subject is notice for invocation of arbitration procedure.
There was no response to this notice.
No response.
What do you say?
Lordship, only I have paid myself, only I have, my part only paid. 8 lakhs only I have paid. And respondent number 2 has not paid.
Where is respondent to the appearing?
He is not yet paid.
Notice served.
Notice has been served. It has been received on 25/2026. No, they are the partners. They are the only two partners of the firm.
I am the new partner. And I already,
You are
I'm the new partner.
new partner.
New partner.
Heard Mr.
And Patiri.
N. Patili, learned counsel for the petitioner. Mr.
Teaching.
Hearing for respondent number
3.
3. And who's for 1?
One is the partnership firm. I have served them Dusty. That was received. My lord, I filed the affidavit of compliance also.
Where is that?
My lords, it's at page number 102. Flag C item. The acknowledgement is at page number 104. Madam. It was received by respondent number 3 only, being the partner of the firm.
You are appearing for 1 also. Mr. G. Gauhati appears for respondent 1 and 3. The petition is filed under section 11(6). The petitioner had and the respondents had executed a partnership deed dated 17th.
Retirement date is at my lord 15.
No, 14. Page number 14.
14 is the erstwhile partnership date where I was the partner.
What is the date?
That is my lord 11/2/2023.
11/2/2023. Partnership deed was between petitioner and the respondent number 2. Subsequently, the petitioner retired from the partnership, and by way of a supplementary deed of partnership, it was reconstituted with petitioner and 3 as the partners of petitioner number 1. And respondents 2 and 3 or as partners of respondent number 1. Petitioner is the retiring partner, same date. And as per the date, the claims of the petitioner and the amount due to the petitioner are required to be paid by the partners of the reconstituted partnership. So, the disputes and differences are very then in respect of settlement of accounts, and therefore the petitioner has filed an application for called upon the respondents, not application, issue the notice under section 21, calling upon the respondents to occur on the appointment of the arbitrator. So this was issued on page number notice
55. It starts at 55.
This was issued on 31/1/2026. However, there was no response to the notice issue, and the consequence thereof, the application filed. The respondents, pursuant to issuance of notice, office note reflects that notice is served on respondent number 2. So, Mr. Gugo appears for respondent number 3 and also for respondent number 2. So, has already been served on respondent 2, and there is no representation on behalf of respondent number 2. Matter will proceed ex parte. Respondent number 2. Stop. Having heard counsel for parties and upon perusal of the meeting report, it appears to the court that there are certain disputes between the petitioner and the respondents in connection with the settlement of dues arising out of the process for retirement, arising out of the retirement of the petitioner, and the same has not been resolved. According to the respondent number, counsel representing respondent 1 and 3 submitted, the respondent 3 has already paid his share of dues to the tune of rupees 8 lakhs. 8 lakhs. And which is acknowledged by the petitioner. However,
I have not acknowledged, my lord. That is with respect to a separate, completely different transaction. I have filed my rejoinder to that also.
the counsel for the petitioner acknowledged for paid an amount of 8 lakhs. Counsel for the petitioner, however, disputes the same submits that this is pertaining to a different transaction and not in respect of the settlement of accounts. But under such circumstances, since there appears to be a dispute between the parties arising out of the settlement of accounts in the partnership, and since no response was received from the respondents in pursuance to the notice issued under section 21, court under the powers under section 11(6) whereby appoints Mr. Mrinmoy Kumar Bhattacharya, retired district and session judge, to act as a sole arbitrator, decide and resolve disputes arising by and between the parties. Stop. The appointment of the prospective arbitrator will be confirmed upon receipt of written declaration by the arbitrator, section 12(1). Stop. The registry will communicate a copy of this order to the prospective arbitrator. Parties are also at liberty to obtain certified copies and approach the place it before the arbitrator. Release this matter on 22nd June.
Review.
On the response number 8 and 9. Response number 10, nodal died. I have to indeed I was not directed to response number 6. That may be
You were directed to?
not directed to issue notice to response number 6. No, but which in respect of response number 6 was not my sent my.
Respondent 6.
6 is the branch manager. From where the bank manager drawing by the business.
All right, let the third counsel for party, let the counsel for petitioner undertake steps on respondent number 6 by speed post within 1 week from today. Office note dated 9/6/2026 reflects service on respondent number 8 and 9. Anyone for 8 and 9?
8 and 9.
However, none represents respondent 8 and 9. Office note also reflects that respondent 10 has expired, which is also acknowledged by the petitioner. So, petitioner is permitted to file necessary application for substitution which was advised in the meantime. Release this matter again after 4 weeks.
Lordship, here in this case, I am appearing on behalf of 1, 4, and 5 Lordship.
Mr. J.K. Goswami,
Standing counsel.
Standing counsel.
Anyone has to be a veterinary department.
Respondents 1,
1, 4, and 5 Lordship.
1, 4, and 5. MS Das. M. Das for respondent number 3. And who's for 2?
The finance Lordship.
P and 7.
P Nair.
Released after 4 weeks.
Lordship, extra copy.
Extra copies, if not already furnished, be furnished to the respondent now. Very good. I have been not here. Yes, we have allowed your application. We have appointed, I think, Justice Musari. P.K. Musari is the sole arbitrator. And we'll refix the matter again on 24th of June for the confirmation under 12. Right? Can also place a copy of the certified copy of the order before prospective arbitration. And based on 24th. List of the order.
I have instruction Lordship.
What is this?
Lordship, here, two proposals, Lordship. Last financial year,
there was a sanction, Lordship, but at the last moment, the petitioner, he stays in Pondicherry, Lordship. So at that time, Lordship, because of non-furnishing of certain documents, Lordship, the payments could not be made. Now, Lordship, the next financial year, the proposal has already been sent to the government. And right now, Lordship, the budget session is going on. So, Lordship, some time will be required to make both the payments, Lordship. We have calculated the pending amounts. A fresh proposal has been sent to the government. Some accommodation may be required, Lordship.
Fresh proposal of 23 lakhs.
Yes, two different amounts, Lordship. 13 is interest on the late pension payment, and 9 lakh something, 9 lakh so and so, Lordship, for area salary. So these two have there.
But the question is, when will the person receive it?
No, Lordship, here the sanction was for the, now he's staying in Pondicherry, Lordship. So some.
That is not his fault. You are unable to send the money from Pondicherry. You don't have to send a special message.
For signatures and all, Lordship, he's not available. That we are doing because, Lordship, tomorrow, if
no, now what is the status? You say the proposal has been sent.
Yes, Lordship. Now the
proposal
budget
is sent placed before which authority?
The government, Lordship, and the budgetary provisions have been made now. Once the budget session is completed, Lordship, within, Lordship, I pray the matter may be listed in the first week of August. By then, the budget will be available and the payment will be made, Lordship.
The Council for the Finance Department
Lordship,
submits
Health
that
Department.
steps.
Health Department.
Health Department.
Lordship.
You are appearing for the respondents here.
For respondent number 2, Lordship, and he has retired, Lordship. I'm just.
He has appeared for respondent number 2. He has been instructed by the Health Department that the proposal for rupees 13,82,341 for the period 12/8 so and so and 9,90,386 amounting to a total of 23,72,727 has been forwarded to the appropriate authorities in the department, and matter is placed before the appropriate authority for allocation of budget. It is submitted that once the budget is allocated, the amounts can be released. Submits the matter being listed after 4 weeks. Prayer made is not objected to by the council for the petition. Accordingly, this matter again in first week of August. 8th of August.
Lordship.
Sorry, 8th is a holiday. 7th of August.
Lordship.
You are appearing for?
Hearing on
Mr. D. Nath, appears on behalf of respondent.
No, Lordship, on the last date, I was on legs, Lordship, no one had appeared. So I think a notice was sent to them.
The presence of Mr. D. Nath is also taken note of. D. Nath, on behalf of the request, upon a request made by the court, is also taken note of. We're dismissing the petition. Get the order.
This is the comprehensive department matter, my lord. The petitioner's father died on 15/6/2004, my lord. Thereafter, petitioner appeared before this honorable court, my lord. Petitioner's father died in harness, my lord, 15/6/2004, my lord. Thereafter, petitioner appeared before this honorable court, my lord. His case is considered, my lord. And again, my lord, rejected, my lord, his case, SLC, my lord. Annexure 7, page 22, my lord. Serial number 1, my lord. Now, my lord, rejected his case, only ground is the under qualification, my lord.
Which page number?
Page 22, my lord.
22. What is the name of the person?
Ashok Datta, my lord.
Ashok Datta.
Yes, my lord. Serial number 1, my lord.
You are underqualified.
Here, my lord
Yes.
mentioned, but my lord petitioner HS pass, my lord. He is in the year 1999, my lord.
You are asking for appointment in the section assistant,
Khallasi, my lord. Post of Khallasi, my
not Khalasi, section assistant.
Yes, my lord. But my lord, last 16 years, my lord, only qualification is HSLC pass. Number of persons are appointed, my lord.
Your case is considered on 2020.
My lord.
On which date? What is the qualification on that date? Mr. Goswami?
Yes, Lordship, instruction received, Lordship. Yes, that Lordship, that the proposal of, he was at that time, he was underqualified. The qualification prescribed for appointment to the said post are as follows.
He is to be considered in which post?
Yes, section assistant.
Why not Khalasi?
Lordship, Khalasi and the post, he was at that time, Lordship,
He applied for SL.
SL, specifically SL.
But are there any vacancies available in Khalasi? You are applying for SA.
My lord. My lord, he is HS pass, my lord. Annexure 9, my lord, page 28. I certificate also.
Page?
Page 28, my lord. He is qualified candidate.
It's completed high secondary final. Why is it rejected?
Was Lordship, it was given, but it was, this is the recent instruction which is short. It was given on 11/06/2026. The recent one.
You passed in 99.
My lord.
There appears to be something wrong here. Mr. Requires minimum qualification of HSSLC.
Yes.
And he appears to be HSSLC.
Something wrong. It should be clarified, Lordship. The instruction itself.
The counsel for the petitioner submits that she is aggrieved by the rejection of her candidature by the SLC for consideration of for appointment on compassionate ground in the post of section assistant on the ground that the petitioner is underqualified. Stop for the post of section assistant, minimum qualification of higher secondary or HSSLC is required. Stop. The learned counsel for the petitioner, referring to annexure 9 of the written petition, submits that she had already completed her HSSLC or higher secondary final in the year 1999 and a certificate to that effect has been issued by the college authorities. Under such circumstances, the claim of the petitioner could not have been rejected by the SLC that he was underqualified. So, Mr. J.K. Goswami, the government advocate, submits that he would like to complete his instructions in the matter. Mr. N. Upadhyay appears for the irrigation department. Released after 3 weeks.
The effect of the instruction says, Lordship, he is a matriculator.
Huh?
The instruction says he is a HSLC pass, matriculator, 10 pass.
The
So requirement is
instructions received by the State Council reflects that the petitioner has completed its SLC. Whereas the counsel for the petitioner, by placing reliance on Annexure 9, submits that he has completed the higher secondary or HSSLC. Let the department obtain their instructions and apprise the court on the next return application.
Lordship, on the last occasion had directed to produce the list of books and the judgments as to why his case is not covered under NC Santosh.
Then SLC minor. Is it that at the date of application, there is no office number of 1/6/2015 is not applicable. But NC Santosh stated that he then judges.
On the date of consideration.
Date of NC Santosh says there were date of consideration. And no doubt father died on 6/4/2015 and the application filed on 27/5/2015. But his consideration by the DLC on in the year 2021. Subsequently, prior to that, the SLC also rejected stating another ground, meaning by balance minimum 3 years. Where I approached before this honorable court,
that is set aside.
That is set aside, and subsequently this honorable court also directed to
Now,
consider
what do you say about this
NC Santosh.
Devobrat Tiwari?
Devobrat Tiwari regarding another aspect regarding consideration long pending case regarding. And subsequently another judgment also passed Canara Bank versus Ajit Kumar stated that if the respondent failed to consider, then ought to have been considered by the respondent. Yes, subsequent to Devobrat Tiwari.
No, your case is on the date when you had filed your application. What was the OM?
OM 1/6/2015.
On the day when you filed it?
No, I have filed application on 27/5/2015. And subsequent OM 1/6/2015. And
1/6/2015. What is the? How is it to be considered? Where is the rejection order of the SLC?
Kindly say 104 and it's a 13.
104.
Minus one High Court judgment, in this context, the Honorable Gauhati High Court filed order dated 2012-2017 in the Bencho is quoted below. Therefore, as long as the application is submitted within the time prescribed by the existing policy of the government, the same cannot be rejected on the basis of subsequent policy decision, which was was not in existence on the date on which the petitioner has acquired his eligibility to apply. In other words, the petitioner could not have been divested of an accrued right to apply for compassionate appointment on the basis of the existing government circular by placing reliance upon the eligibility criteria which was not in existence on the date on which he had acquired the eligibility. It is therefore held that office memorandum dated 1/6 will only have a prospective application. On that basis, Malad rejected. It's a 2017 order, Malad. Subsequently, Malad, NC Santosh Malad, even time. Said that Malad, at the date of consideration, Malad, applicable guidelines applicable on the date of consideration.
Your case is that it should have been referred to other
Malad.
departments to find out. Then what is the respondent's stand?
The NC Santosh judgment, if Lordship may peruse. Here, my lord, the aggrieved party, they discovered that their appointments were made divorced to the provisions of the Karnataka rules for compassion appointment as amended, and those appointments came to be cancelled. Lordship, the amendment to the proviso, it stipulated that a minor dependent of a deceased government employee, he or she must apply within 1 year from the date of death of the government servant.
This is not the case here.
Yes, my lord. That is why NC Santosh will not apply in this instant case, because, my lord, the NC Santosh case was on a different issue altogether. And here, my lord, in NC Santosh, the very eligibility was questioned. Here, my lord, he was eligible.
Eligibility was questioned in terms of the office memorandum on the date of consideration.
Yes, my lord.
So the question was whether the office memorandum on the date of application will apply or date of consideration will apply.
Date of death will apply, your lordship. Because in NC Santosh, it was held that applying the law governing compassionate appointment culled out from the above cited judgments, our opinion on the point at issue is that the norms prevailing on the date of consideration of the application should be the basis for consideration of claim for compassionate appointment. A dependent of a government employee, in the absence of any vested right accruing on the date of death of government employee, can only demand consideration of his or her application. He is, however, disentitled to seek consideration in accordance with the norms as applicable on the day of death of the government employee. This is held in NC Santosh.
Paragraph?
Paragraph 19.
19.
Because here, my lord, the issue was whether after the amendment was done, he was cancelled of his appointment, because a minor could have applied only within 1 year from the death of the deceased parent. Earlier, the amendment was not there, and the lordship, the position was different. A minor could have applied till he attained majority within 1 year of attaining majority, lordship.
It says that he is disentitled to seek consideration in accordance with the norms applicable.
Yes, here, my lord, because the issue. Yes, my lord, because the issue here is different. But unlike in NC Santosh case, in the instant case, we are only concerned with the applicability of the OM dated 1/6/2015. So far as the same relates to the accommodating candidate seeking compassionate appointment in departments other than the parent department to accommodate the employee. And my lord, in the earlier OM,
the earlier OM, the reference to other department was
not there.
In subsequent OM, it is there.
It is there.
And also the minimum 3 years was also there, but which has been struck down.
Yes.
Now, at the time when the father died and the person made an application, it was the earlier OM.
Yes. Yes,
And on the date when the matter was considered, it is the subsequent one.
subsequent one.
Now, as per NC Santos, it is the subsequent one. which will
My lord,
apply.
after NC Santosh, another judgment of 3 judges bench, same strength, my lord, was issued.
Which is that?
Amit Shiva.
Yes.
Here, my lord, it was held.
Yes. Hmm.
Here, my lord, the issue was with regard to the permanent or ad hoc employees who are eligible for compassionate appointment. Whether at para 15, lordship, in our opinion, the only issue which has to be examined is whether the late father of the respondent, who admittedly was employed as work charged contingency employee in the tribal welfare department, was entitled to compassionate appointment as per the existing policy on the date of his demise. 16. It is tried to say that there cannot be any inherent right to compassionate appointment, but rather it is a right based on certain criteria, especially to provide succor to a needy family. This has to be in terms of the applicable policy as existing on the date of demise, unless a subsequent policy is made applicable retrospectively. Here, my lord, the scheme is admittedly not retrospective in nature, 1/6/2015. Insofar as providing succor is concerned, unfortunately, since the demise of the late father of respondent, 11 years have passed, and really speaking, the aspect of providing succor to the family immediately does not survive. We have still examined the matter in the conspectus of applicable policy. It is not in question that the policy prevailing was so and so.
What about Devabrat Tiwari?
So after that, my lord, Devabrat Tiwari also said, my lord. After that, my lord, one more judgment is there. In 2021, 20
All right,
SCC.
continue because you have given the list, right?
Yes, my lord.
Okay. Take out the judgment and we'll continue with the matter on when?
Any hearing date?
23rd July. The matter is ready for hearing. It is for hearing on 23rd of July.
Wait, lordship, 23rd
3rd of July.
3rd of July. Obliged.
Party naam dena, council naam dena. Yes.
The petitioner for pension benefit. Really, a banker. I was really a banker temporarily for State Bank of India from 27/8/1992 as per appointment letter, and 19/12/1994, and lastly 25 July 1994. So by the branch manager, my lordship, Kotoha branch. But my lordship, in some unavoidable problem for health issue and family problem, I was applied for my voluntary retirement from the bank, from my job. But at that time, I have not knowledge that I will not get my pension benefit, because my lordship, one official, as a senior official, advised me that I will get my pension benefit if I completed 10 years my job, my lordship. So I have applied for voluntary retirement, but after issue of the releasing letter, I have come to knowledge that I am deprived from pension benefit, my lordship. But my lordship, according to pension policy, exit pension exit option.
Wait,
There
let
is-
us find out what you want to file in the response here.
Our affidavit is already on record. What is, whether they have opted, the petitioner opted for voluntary retirement, and according to the, it is a policy in itself, all the
There
retirement
will
and
be an
benefit.
additional affidavit. When did you file it?
24 to 26.
Not here.
Yes, my lord, 24 to 26.
24/3.
Yes, 24
Not
March.
here. MSM Bourbon for the petitioner, Mr. G. Jalan for the respondent. According to Mr. Jalan, an affidavit has been filed on behalf of the bank on 24/3/26. Stop. Registry to verify and trace out connect the affidavit stated to be filed by the SBI and connect it to the case record. Matter be listed again after 3 weeks. Petitioner may file rejoinder if they're so advised.
I have already filed my reply.
You have also filed a reply.
I have not received the copy.
It is not here.
Reply, I have not received.
Reply. No, already
Kindly go.
served, my lordship.
The counsel to the petitioner in turn submits that she has also filed a reply
My clerk.
to the affidavit filed by the
My clerk
bank,
already.
but
Here.
the same is also not available on record. Registry to trace out and connect to the case record.
It is maybe direct to serve a copy. Copy is not
The counsel for the petitioner will serve extra copies of the affidavit filed to the counsel for the respondent. No, not necessarily. We'll get it from the registry. It's not available.
Not on record.
That is my lordship.
Not on record.
This is the acclaim.
We have recorded that you have your statement that you have filed it. It is not available. We have directed registry to get it after the next date, after 3 weeks.
Okay, bye.
Yes.
This case, second round litigation has been filed by the petitioner for regulation of her services. The previous honorable court order dated 19/2/2022.
Any response you are required to file?
Lordship will file a application. It may come up after the vacation.
The coordinate bench of the honorable court recently passed the order of this squarely covered my case.
Give us a copy, share with him a copy. Let him examine the order and tell us. Notice has been issued in the matter. The counsel for the respondent submits that they would like to file their affidavit in a period of 3 weeks. Further submitted by the learned counsel to the petitioner, and the matter stands covered by order dated
Order dated 8/6/2026.
8/6/2026, passed in WPC
3157
of
22.
22. What is the name of the party?
Robin Chandra Roy and two others.
Robin Chandra
Robin Chandra Roy.
Roy and others.
Suggested.
List after 3 weeks.
Mechanically.
Let him file the affidavit, then you make a mention and fix a date.
Your lordship, they have willingly denied lordship. Number of cases they exam.
No, if they don't,
example, lordship.
that is what we are saying. If they don't file, you make a mention and have it listed. If they don't file,
After expiry of time. And
you make a mention.
yes,
Yes.
lordship.
Yes.
So last time we had to.
Yes, some records were to be traced out or something.
This is for appointment of arbitrator, at least, 11.6.
The last order said that some records, trace out the relevant records or something by Mr. B. Chaudhary. Anyway, any objections here?
I'm not objective, only the liberty that in case of any object, grievance relating to jurisdiction or anything.
That you always be able to raise, but something for the petition parties. An application under section 11.6 and the petitioner was issued a work order in connection with page number 14 work, construction of so and so. Where is the work order dated? The month of February 2016. And petitioner claims to have completed 34% of his work, but no payments were made. Subsequently, the contract was terminated. Stop according to the petitioner, amount of rupees 50 lakhs along with interest, totaling to 64,50,000. The total claim to 1,14,50,000 has been claimed. This not having been resolved, the petitioner has issued referred to clause. Where is the clause?
So this is my lord. It's admission for page 141, my lord. Subsequent 141.
Clause 20 of the GCC, which provides for arbitration. So in terms of the in terms of the said clause, since the disputes were not resolved by the department, the petitioner filed issued a notice under 21. Where is the notice?
My lord, the page 49.
Dated 3/7/2023 on the chief engineer, following up on the chief engineer to appoint, concur on the appointment made. However, there being no response, the petitioner has approached his court. The writ petition did not contain the GCC, therefore, on liberty being granted by the court, but the GCC was brought on record by filing additional pleadings. So, the respondents have not expressed any objection for appointment of the arbitrator, with the limited prayer that they may be permitted to raise any objections, if any, before the arbitral tribunal. Stop considering the same. The court is of the view that under powers conferred on section 11.6, the court appoints Justice Manojit Bhuya, former judge of this High Court, as the sole arbitrator to decide on the disputes arising by and between the parties and pass appropriate awards. learned prospective arbitrator will file amended the written declaration under clause section 12(1) of the Arbitration and Conciliation Act. Copies of this order be marked to the learned prospective arbitrator by the registry of the High Court for the communication. Parties are also permitted to furnish copies of this order. Let the matter be listed on 24th of June. 24th of June. All right.
Kindly pay me the order dated matlab last order matlab. This case matlab PP already issued matlab in the month of October matlab. But in that matlab treasury officer have not released. Therefore,
Yes. Where is the Finance Council?
therefore we have
Any instruction?
Yes, Lordship. Here, Lordship, only the refund from the government share of the petitioner needs to be refunded, Lordship. So they are actively sitting on it, Lordship. They are saying within 10 days it may be resolved. So if Lordship may fix it just last week of June, on that day I can get a concrete instruction because they just need to make the bills after that.
All right, 22nd.
22nd, yes, Lordship.
Matter be registered on 22nd June, enabling the learned counsel for the Finance Department, Mr. A. Fukan,
A. Solian.
A. Chalia, to obtain the required instructions from the Treasury. Which Treasury is
Lordship, Director of Accounts and Treasury. Actually, they are the authority.
Director of Accounts and Treasury.
Yes.
Released on 22nd.
22nd of June, Lordship?
June.
Yes, June.
Mr. Musari for PTC. PTC, Mr. Banerjee for 1 and 4. MS, H. Sharma for respondent 5. Mr. Chakraborty for respondent 2.
item number 28.
Mr. K.R. Patgiri for the petition. 28
also same.
28 also similar, list on 22nd.
My Lordship. Obliged.
We have received our para-wise comment, let's say 2 weeks time maybe.
None appears for the petitioner on call, Ms. RDB, CBC submits that instructions are complete. She would like to file her affidavit. Prayer is made for filing, prayer is made to defer the matter for 3 weeks, enabling her to file the affidavit. You're appearing for?
Respondent number 7, my lord. Sometime has
Who's the respondent 7?
find the respondent number.
Commandant.
Mr.
B. Bomo,
B. Bolwine appears for respondent number 7, who also submits that 3 weeks time be granted to complete instructions and file necessary affidavit.
No, my lord. We have some time because we have to prepare contact the plan as we are not want to pursue the matter, my lord.
You do not want to?
Pursue the matter, my lord. Continue the matter as we are supposed to get the instruction from the plan.
Whatever, we are giving you 3 weeks time. Released after 3 weeks.
My lord, this matter pertains to non-release of compassionate family pension. This case, my lord, they have no cogent reason to hold the family pension, but yet it is hold. So this requisition, my lord. Yet they have no reply, my lord. For the last 2 occasions, they did not find any response. When they did not objected for canon. So
Yes, what is there? Why family pension is not released? PHE.
PHE, Lordship.
All right, time big. PHE. Standing counsel.
Repeat, Lordship. Lordship, in this matter, we have received our instruction. We'll be filing an affidavit.
Mr. K. Rahman for the petitioner, Mr. A. Puban, standing counsel. What is this? Secretariat, Administrative Department. Huh?
Secretary, Administration Department.
Administration Department submits that he would like to file his affidavit and instructions are complete. Please for 3 weeks' time. Prayer made is not objected to, release the matter after 3 weeks.
One date may be accommodated.
Let him file the affidavit.
Fine.
If he doesn't file, you make an mention before
Fine.
the court.
Deeply obliged.
Obliged.
Yes.
Item number, my lord. 36 lakh quality. My lord, it is complete.
Pleadings are complete.
Here in 36, my lord, please are complete. Other two, other person, my lord, is some, they have not filed.
What is it that you want?
Participant 38, we have filed affidavit, and 34 to.
What is your case? Tell us.
My lord, take my lord 36 months.
36.
In this case, my lord, the petitioners, my lord, were ex-Hungars, my lord. Initially, they were, my lord, they passed, my lord, Hungar basic training, my lord, and they were engaged as Hungars. After some days, my lord, they were discharged. Thereafter, my lord, the year, my lord, 2011, my lord, 10, my lord, they were engaged as, my lord, SPO, my lord. Special Police Officer, my lord.
What praise do you want? What is their relief sought for? Mr.
Relief,
Chaudhary, you are appearing here.
Yes, my lord. Basically, my lord, what they, my lord, people are the ex-Hungars. And as per Rule 23, my lord, normally they can have my lord, a special SPO, my lord. So they are normally used for that one. Now, what they are doing, my lord, these people are working. Now they discharge them and they take some other person in their place. That's why I came before Lordship, my lord. This person
They are discharged from Home Guard.
Home Guard.
And some
And
other
stay
people
in
are-
the other person in our place, my lord. So that was the reason, my lord, why we appointed your Lordship, my lord. So our question, my lord, if there is any, suppose they are now already age also almost over, my lord, and they are continuing.
They are continuing where?
Till today, my lord, so far item number, item 34 and 36, my lord.
There's an interim order.
Interim order. And so far, item 30, my lord, Vishwajit. Item 36. Only. This is my Vishwajit, my lord, and 8 others. So, 35, 36. Item number 1. Thirty-four, 35, 36. And only about 37 and 38 not.
Is there an age limit for the Home Guards? Is there any age limit for Home Guards?
My lord, so far SOP is concerned, my lord, as such there is no. As such we do not find.
What is the strength of Home Guards?
God's strength, my lord, strength I don't know, my lord, but regarding their pair to absorb and regularize. Supreme Court says they are not entitled for regularize. And absorption.
Regularize is what? Constables.
Yes.
That's what they are, my lord. Actually now is fine.
Actually, but what happened when
They are trained home guards.
they are trained home guards and they when and necessary they were deployed. And they are deployed for 6 months normally. And thereafter they were released. Again, if there is situation arises, they will be called for and they will be engaged. This is their policy. Actually, home guard conception was in the conception was come to the India after Second World War. Then in the West Bengal, 1962, when the China aggression was there, the home guard conception was there. They are saying as voluntary person, because to help the police police officers and the police and the civilian, the home guards were created, and they are paid their allowances, not as a salary. Now, what happened in Assam, what happened in the batch of petition was filed, that was dismissed on the basis that they were sent for the troublesome area, Kukraja, Dhuburi, like the National Highway, as a PSU. And they have said some were engaged, some were not engaged. And therefore, they asked the government to absorb them because they have an experience. So, government in 2017 made an advertisement and they have a partial.
Now, what proposal do you have?
My proposal is, there is no any such specific proposal. There is to absorb and regularize or regularize
As
a constable. So as constable,
alright, as constable, not accepted.
Not
but
accepted.
As home guards,
home guard cannot be regularized.
may not be regularized, but their employment engagement.
The employment engagement as and when necessary.
But as and when necessary is very uncertain. Somebody
Uncertain.
is engaged for 6 months.
Their service condition is uncertain.
Then why have you trained all these people? And
No, they because they will have to help the people, police officers and others.
you ask the department to frame a policy. There must be some policy that you cannot pick up people, train them, use them, and then throw them out.
The home guard concept is that but they have
In
voluntarily
today's
come.
concept, are you saying that there is no need for engagement of home guards? There are.
There's a need, Balu. There's a need.
Then
But so that is so
unless you say that no, these particular persons have got adverse remarks or
yes, exactly. Balu.
there are police cases.
In some
pending.
other cases, I came across Balot. Some home guard against their advance report, they involved in the docaity and extortion of money. They were released. No, not this petition. Exactly. Some
They are bound to, because you have not given them employment. What will they do?
then Balot, what happened, Balot? In this petition, Balot, they are saying that they are deployed as a SPO. They will be regularized in their.
No, we are not on that. SPO, constable, nothing. But they are home guards. It is your case that as and when required, their services are to be
utilized.
Now, is there no policy available that maybe 6 months, let us say, every 6 months you renew their deployment?
Yes, to continue their services. It is in the home guard, X, there is a provision. There is a provision, their tenure is for 6 months.
So the question is that how is the deployment worked out?
Deployment work at suppose law and order situation
Is it on face value?
Sir, in a law and order situation is there is a hesitation is there to help the police official, they are engaged as and when they call. And now, continuously they cannot be kept for the job. So that is the situation. Now, Lordship asked me to actually government should make a policy, uniform policy, so that home guard, those who are helping the police personnel, they should be at least ensure that their service is secured. But that policy is not made.
You come up with some policy here. Come up with some policy, or you want us to give a direction, we'll give you a direction. But there has to be an effective policy somewhere.
Regarding this policy,
are they entitled to any benefits like
no,
not pension, but
pension, no.
Then
their daily wage basis, initially they were daily wages basis, they were engaged.
Context, how can you extract services from somebody and then throw them out and say that they are not required?
Until and unless government they pass an act regarding their service and
terms
Yes,
and conditions.
Mr. Chaudhary.
My lord, so 23, section 23 Police Act is concerned. The
Police Act.
possible fund, especially police officer, they are SPO.
No, but
Not
special
constable.
police officer has to be
Not constable, my lord. What they are saying, my lord, they're also.
No, but there has to be a policy by the government
Yes,
that they
that is
require.
not there, my lord.
That is
What
not
they
there.
do, my lord, pick and choose.
Act is there, madam. Assam Home Guard
Yes, my
Act.
lord. That is there, no policy. Let them make a policy, my lord. And these people are getting a fixed pay of something, my lord, only. They cannot maintain their family. 16, 17,000, I think, my lord. And since 2010, they are working, man.
No, madam, there is a Home Guards Act 1947
Yeah,
and
that-
Home Guard Act and Rules 1947 is there.
Yes.
So,
Yeah.
my lord, it's not available with me, my lord. I will go through it, my lord, how it is deal, my lord, how it is dealt by the, my lord, persons. So let it be, my lord, in some other days, my lord. I will go through the Rules and Act. They are
Let them make a policy also, my lord. I have
no,
nothing to
regarding
say.
policy, I cannot say without instruction.
Anyway, no, you cannot make, but honorable court may direct you.
Not an ADC state, my lord. I will have to go through
Anyway.
the Act and Rules.
These petitioners, only two of the petitioners are protected by interim orders.
Yeah, now, item number 34, 35, 36.
They're what?
They
They're
are working
working as home guards.
as home.
But last occasion, my lord, interim order was not extended. Interim order was not extended by order dated, my lord.
Number 38 is concerned, my lord. I have been told, my lord, in spite of interim order, they have been discharged. Item 38.
Last
We
occasion,
asked them to file contempt petition.
Who issues the engagement and discharge orders?
There is normally a commandant.
Oh,
Commandant,
District Police Commissioner, my lord.
Yes.
Commissioner of Police.
is it the SP or the
SP
Yes,
and
SP.
police. Yes,
SP?
yes. Superintendent of police and reserve police officer. Respondent of 4 in item number 36, man. 6 is the lead case, man.
Mr. Churia, you file your comprehensive affidavit to tell us what is the requirement, if any,
Yes, yes, yes.
as per the department,
Department.
district-wise. Bring it on record.
My lord, the last
And
occasion,
then any policy, if it is there, we'll see what can be done.
my lord, the last occasion matter was listed on 21st of May 2026. But earlier interim order was not extended.
That is not a ground to
No, my
discontinue.
lord, I'm pointing out the, my lord, facts.
Let them file another comprehensive affidavit. Mr. H.R. Chaudhary, learned senior counsel, assisted by Mr. O. PS for the petitioners, Mr. T.C. Sutia, additional senior counsel, senior counsel, senior counsel. State the petitioners are trained home guards who were rendering services under various in various districts, and some of whom were released after deployment for 6 months and has not been redeployed again. And some of the petitioners had approached this court and they are protected by interim orders. Petitioners in item numbers
38.
38.
In spite of interim orders, they have been discharged.
No, who's got interim orders? Tell us.
Yes. Interim order except item 37.
All the others,
All the others,
34 to 38 except 37, according to the council, the petitioner are protected by interim orders. So the senior council submits that their initial prayer was to appoint them as, engage them as police constables and in armed branch or unarmed branch, and thereafter regularize them. Stop. As on date, the learned counsel with the petitioner submits that there must be a policy in place for deployment and redeployment of trained home guards, subject to certain provisions being laid down regarding the policy for redeployment. So, Mr. Churia, on the other hand, submits that there is no such policy as on date. He also does not have the instructions as to the total strength of trained home guards and requirements, if any, district-wise. So, under such circumstances, we permit the learned senior government advocate to file a comprehensive affidavit to bring on record the total number, total strength of home guards in the state, and the requirement district-wise as per the records. Let this affidavit be placed on record within 4 weeks. Meanwhile, matter be listed after the returnable date. Interim orders, wherever granted, will continue.
That is only one district. All the petitions are from one district.
On one district.
One
Which
district,
which district is it?
Sribhumi now.
Sribhumi, only from Sribhumi.
Oh, no, I am sorry. Oh, your order is correct. So I am sorry.
Let it be after the returnable date.
But one thing, my lord, my submission, because of the not having policy, my lord, they are discharging and engaging on pick and choose basis. That is the main question.
The
My
petitioner or submission only, the learned senior council submits that because of the absence of any fixed policy, the trained home guards, like the petitioners, are deployed and redeployed in a pick and choose manner without there being any policy for such deployment or redeployment, causing putting the trained home guards, like the petitioner, to face complete uncertainty regarding their livelihood.
Made clear. Workers, after the final merit list, they were cancelled saying single candidate. On last occasion, instructions were thought of on the state. The instruction is not received, Lordship. I have to take the instruction. After vacation, Lordship, along with the instruction.
Yes. Mr. T. Loswell for the petitioner, Mr. J.K. Goswami, learned senior government, additional senior government advocate for the respondent, who renews his prayer for further time. He submits that the matter be listed after 4 weeks, enabling him to obtain instructions. Prayer made is not objected to, released after 4 weeks.
Your Lordship, pursuant to the order dated 15/2026 for release of provisional pension, Lordship, I communicated this order to the department, Lordship. I have received the instruction, madam. Kindly allow me to file my affidavit.
Provisional pension, what have you done? Release of provisional pension? I don't want to see. Tell us whether provisional pension is to be released or not.
No, madam.
No.
They have written that petitioner applied for the subject to merit of this case.
MST Som, learned counsel, appeals for the petitioner. Ms. M. Das, learned counsel, standing counsel, PWD.
Fine.
Submits that the instructions are complete. She would like to bring it on record by way of an affidavit. Needless to say, if the rules permit, the petitioner will be, the respondents will release the provisional pension to the writ petitioner during the pendency of the writ petition.
Pendency of the criminal petition is not a part that has been observed by this honorable court as well as the apex.
We have indicated that. Let the affidavit be on record.
Right. And the date may be fixed, Lordship. So that, because it's also
29 July.
29 July. Obliged, Lordship.
Lordship, in item 42 and 43, Lordship, I have filed my affidavit on 9th of June, Lordship, but the same is not on record. Both the
Have you received copy?
I have received copy, my lord. My lord, they were asked to file affidavit on 15th of March, May, my lord. Now they have filed affidavit on the very last day, my
They
lord.
have filed.
Yes, my lord. So if my lord, by the time
You don't want to file rejoinder.
my lord, I'll give my lord oral submission because by the time the matter will be listed next time, my lord, the matter will become infractual.
Why?
Because they will fill up all the posts, my lord.
Post for?
For my lord, a technician for CSS and technician for assistant CSS.
MS SB locker for the SB Chaudhary for the petitioner and Mr. D. Upamanyu, standing counsel held. Mr. Upamanyu submits that he has filed the affidavit on behalf of the department. Stop the same, however, are not connected to the case record. Registry to trace out the affidavits and connect it to the case record. There are two matters or one matter? 42,
Matters,
42
my
and 43. 42
This
and
may
43.
come up on Monday, my lord. Your lordship may, my lord, hear and
Monday is not possible. They'll have to trace out today is Friday, tomorrow is a holiday. How will they trace out the affidavit? Be reasonable in making your
then
prayers.
Tuesday or Wednesday. Otherwise, my lord, my petition will become infractual, my lord. The petition, in spite of being
All
eligible,
right, 17th,
declared eligible, he has
based
not
on
been given
17th of June,
appointment.
in view of the urgency made, prayer for urgency by the council. It is submitted by the council for the petitioner that she would not like to file rejoinder affidavit.
Yes.
bad reason.
I was directed to place the original appeal. I'll put the DLR. That is received.
Why was it asked for?
Because the court want to see whether he has paid for the DLR for seeking appointment. Seeking appointment of ground town. The impugn order was passed.
So who was appointed as a Gambura?
Appointed one Anwar.
Private respondent.
No, here is not the private respondent in the appeal.
Okay.
In the
Then
appeal,
you challenged that in the appeal.
yes.
What is the status of the appeal?
Appeal disposed of. The appointment of Anwar Hussain was set aside and was.
Set aside.
Yes, ma'am.
Where is the order of the appellate authority?
State authority order was page 34 of the report.
Yes.
Operative portion, your lordship will find at page 38, my lord.
Yes, now.
Now, lordship, my prayer is that since I am the second scorer and the select list was valid till the disposal of the appeal as per order of this honorable court. So, after setting aside and quashing of the appointment of the Anwar Hussain, I should be appointed in the same.
Who is holding the post now? Who is
Right.
holding the post?
Own mind.
Suppose no, lordship, the nearby ground town of the village. Generally, has been allotted additional in absence of any ground town.
The select list was meant for this particular, how many posts?
Only one post. One post. That one condition stipulated in the advertisement is there. Lordship.
But there is no direction to go for fresh selection.
No direction.
Then What stops the DC from taking steps? DC?
One instruction. May I read? So, regard to statement made in para 9 of the like to state that under the Assam Land Revenue Regulations Act 1886, order rules and executive instruction frame thereunder for the automatic appointment of the next candidate in the merit list upon cancellation of the selected candidate. Further, in the advertisement published in the letter dated 1/12/21, there was no such clause condition mentioned where it was notified that in case of cancellation of appointment of the highest marked squares, the second highest squares will be automatically get selected for the post. As such, the deponent stated that in view of the vacancy created against the seat post, press advertisement will be issued shortly to fill up the post against where the petitioner may also apply.
So what is your grievance?
My lord, by the same advertisement, there are a number of lots where advertisement for the post of Gauhati. One such post was challenged before this honorable court. Accordingly, after setting aside the earlier one, the petition was directed to be appointed.
Petitioner was directed to be appointed. Present petitioner.
No, man.
Separate.
It's another petition. By the same advertisement.
Where, which paragraph?
The order is here, my lord.
Oh, no, in the judgment, where is it given? Paragraph.
The judgment is also.
Where is the direction in the judgment for appointing you?
No,
In the High Court order, there is no order. But as per this order, the administrative order is.
Past is past, but there is no direction by the court.
That particular case, the different number was not given. That circumstance, this order was case of person.
No, but there is no direction.
No direction, no direction.
No direction.
There is no direction from this
Appear
honorable court. But my submission is that
Huh.
since in the same advertisement, one candidate after setting aside the next candidate is appointed, so I
File your representation before the authorities. You show us any law that there is right for you to be considered, notwithstanding the setting aside of the appointment.
earlier when I approached this honorable court, the selection list was stayed mine. Until the disposal of the appeal, the selection is in existence mine. So from the said select list, while the
Show us some authority. Ordinarily, once person is appointed, there is no scope for waiting list. Now, only issue is that his appointment has been set aside. Now, whether, and there is no direction to go for a fresh appointment, whether your candidature can be accepted. That's the only question.
some accommodation may be given, but I will submit my appeal.
The request made by the counsel for the petitioner, matter stand referred to this state again. In the 4th week of July. Mr. S. Doctor for the revenue, Mr. H. Chakraborty for
3 and 4.
3 and 4.
Deeply of
Of
And but the issue is covered by the
judgment passed to the apex court recently.
Which judgment?
The master and workers is to the
Your Lordship. The engaged counsel is in another court at the moment, engaged in another court.
Who?
P. Chakraborty, Your Lordship.
You are here.
Kindly take the matter after some.
Yes. After some time.
Lordship, this matters, Lordship. In 50 and 51, we have filed our affidavit. In 49, I pay for some time to file my affidavit, Lordship.
Yes, Mr.
I have absolutely.
Mr. D.S. Tapadar for the petitioner, Mr. D. Upamanu for the respondent who submits that he would like to file an affidavit in item number
49.
49. Prayer made is not, prayer made is allowed, it's again after 3 weeks. It is submitted that in item, in case of number to be given, so and so, petition affidavit has already been filed. List all these matters together again after 3 weeks.
Highly. My expert will be there. A fixed date.
29th of July.
I'm the apply.
in this case, my lord. In this case, my lord, all pleadings are completed, my lord. My submission is that, my lord, what the attitude they have taken in the making the selection, my lord, that is totally adverse to the settlement of the settled position of law, my lord. Whereas, my lord, 2025, my lord, honorable 5 judges of the Supreme Court has passed an order making some direction, my lord. They are not followed single line of that direction, my lord.
Take it up again on
My lord,
27th.
short time may be given, my lord. Otherwise, my lord, what happened, my lord?
We want a shorter time.
Yes, Lordship. What happened, my lord? In this case, my lord, there is a
All right, 22nd of July. You want some water? Honey, you need it? Sit down, take it.
Sorry, Lordship.
No, you don't have to be sorry, but this is why you shouldn't break the rules. Rules are made for convenience of all. You have broken the rules.
Sorry, my lord.
For your own safety, don't break the rules. No chewing while submitting. Whatever you have to do it outside. It's very dangerous, don't do it. We'll have it on 22nd July.
July or June?
July. 22nd July.
Highly. In the meantime, the remaining posts could not be filled up, my lord.
Whatever is there, we'll hear it together. Why piecemeal orders? 22nd of July. Yes, Mr. Botago.
Well, the petition can be, my lord, disposed of in terms of page 41, my lord. The principal accountant general had placed some queries to the executive engineer, my lord. Let the petitioner approach with these responses.
That communication was been going on, my lord. That is why I am before your lordship. In this case, my lord, we have submitted everything earlier. And they are saying something which is, my lord, not tenable. The facts of the case, my lord.
In 30 days, my lord.
Now the question is that when was the marriage solemnized?
That marriage, my lord, was solemnized on 1/11/1981. Only 1981, which was, my lord, dissolved 29/4/1984 by way of divorce deed, my lord. And that, my lord,
the second marriage was solemnized on 1990, my lord. And I was appointed on 1/3/1984 as a casual worker. Subsequently, on 1/12/2003, I was regularized.
Where have you stated all this?
My lord.
Which enclosures?
My lord, kindly see the page 16 to 19, my lord. Page 16.
This is an agreement.
My lord, this is the divorce deed, my lord.
Divorce deed.
It is a mutual, it's a talaknama, my lord. It is a mutual agreement. But that person was died. Only one mistake. What happened, my lord? I mean, only one mistake we have committed. Not mistake. We have, my lord, while making that the next to kin certificate, and we have bona fide, my lord, inducted the name of that daughter which was born out of wedlock of that, my lord, wife, my lord. Only for that, my lord, that issue is raised.
No, how is that a mistake? It can't be a mistake.
Not mistake in that. Subsequently, my lord, what happened? That person died already, and there is no issue in this regard. That the daughter who was
No, you claim to be the second wife of Abdul Khalik.
Yes.
Khalik expired on 4/4/2020.
2020.
You got married when?
I got married, my lord, in the year 1990. It is page 28, my lord. 18/7/1990. I got married.
28.
18/7/1990. Page 28, my lord.
Is by Kabirnama.
Kabirnama.
Oh.
That is a Kabirnama, my lord. That is.
Then
what happened, my lord? They are, my lord, first of all, they hold my pension only saying that since there was one Rubia Begum who was a daughter of the.
What happened to the first wife?
First wife died now.
Any death certificate?
Yes, death certificate I have annexed, my lord. It is page 42.
40. Then?
And my lord, the daughter of that first wife and the children who is of the second wife jointly filed an NOC, my lord. Jointly given NOC, my lord. This is, my lord, page 37. One affidavit we have submitted along with that Rubia Begum, who was the daughter of born out of wedlock of first wife, my lord. All children given the NOC.
Where is the original Kabirnama?
That the second wife. Yes, madam. This is the Kabirnama.
You have the original.
This is that one, my lord, I have annexed.
Page number 28.
Page number
English
20,
translation.
Page number 28 and 29 is the translation copy. Original is the page 30 and 31.
So do you have the original copy with you?
Not original copy, but that copy. This copy. This is the Xerox copy of that.
You got a Xerox?
Original with my client.
With your client?
Yes. There, my lord, kindly see the page.
What is the legal value of the Kabirnama?
In fact, my lord, the nominee is given already, my lord. In the nominee page 20, page 29, my lord, kindly see for a moment, kindly see that page 36, madam. These are page 35, 35A and page 35A, madam. This Hannah Begum, this is the present petitioner whose name was given as the nominee, madam. Page 35A, madam, can be seen. Hannah Begum is the nominee, and page 36.
Why are you not proceeding on the basis of these papers?
That is
My
procedure.
lord, may see page 39, my lord, why it was returned. That is there given by the Office of the Accountant General that they are insisting on a court decree to show that the previous marriage was dissolved.
Who's for the accountant general?
One letter dated page 5, where we have written a letter to page 5.
That we have seen. It is enclosed to the writ petitioner. Writ petition. But where the name of the petitioner is there included in the as a nominee, why are you making these objections? This is already there in the nominee form. If any objections are to be raised, it is to be by the administrative department. Who are you representing, Mr. Talukdar? Where is he? Not in the court. So instructions are that you are raising an objection on the basis of 28th of this 28th of May or something like that. 28th of May, isn't it? So the question is why if the name of the petitioner is included as a nominee and there is no objection by the administrative department, why are you raising this objection? Saying what? Letter to whom?
Department.
When is Mr. Talukdar available? Monday. Keep it for Monday. You ask Mr. Talukdar to obtain instructions as to why they are raising objections here. Monday.
What Tuesday, madam? Monday, I have some. Tuesday.
We are anxious on behalf of your client to dispose of a matter, and you have to make alternative arrangements.
No, madam.
The claim of the petitioner is that she is not given the pensionary benefits which she had claimed on behalf of the late husband so and so, on the ground that she is the second wife. Stop these objections are raised by the Accountant General's office. Counsel for the petitioner has referred to an extract of the service book where name of the petitioner is shown entered as a nominee. So the department, the administrative department, namely PHE, has not raised any objections as to whether the said nominee regarding the petitioner as a nominee. So it is not understood as to why the Accountant General's office is raising an objection in spite of the name of the writ petitioner being found in as a nominee in the service book or late husband. So, Counsel for Accountant General, Mr. R.K. Talukdar, why it is informed is not available in court. Therefore, the matter is directed to be listed on. All right, let us do it on 17th. You ask him to obtain instruction, 17th of June. We list on 17th. Mr. Bothakur, is for the PH. Yes.
Public.
Lordship, this is come up, this should come up for motion, Lordship. Notice yet to be. On the last
Motion.
occasion, we raised the objection of this
Maintainability.
territorial jurisdiction issue. Was fixed
Matter
at
be
the
relisted for motion next week
Monday.
and on Monday.
Okay.
Monday. That is agreed to by the council for the party. This Monday, yes.
Can it be?
Wednesday. That is not a ground for adjournment. Wednesday? All right, Wednesday.
That spaces that cannot get retired as master worker.
You said it is covered by?
Yes, covered by the Honorable Apex Court Judgment. Sukhendu Potterji versus the State
Is it?
Commission.
No, Lordship, we'll file an affidavit in this. Now, this will open floodgates now. We'll file an affidavit.
Can it be in the month of August?
We'll file, Lordship, by then.
The direction, this judgment is to be complied within 1 year.
Yes.
They have 1 year.
So we'll have it next year.
My petition is not getting anything. Yes, served since 1985.
It is submitted by the council for the petitioner that the issues raised in the matter stand covered by the judgment of the apex court in Sukhendu Bhattacharya.
Yes, sir.
Civil appeal number so and so.
4514
4514 of
25.
25. MSP Bhattacharya,
Chakravarti.
the Chakravarti, the standing council PHE,
On water resource.
Water Resources, and Mr. H. Aliha, standing council finance, and submits that they do not subscribe to the submissions. They do not accept the submissions of the council to the commissioner and would like to complete their instructions and file necessary affidavit. MS so and so appears on behalf of Mr. R.K. Talukar. Release this matter again the month of August, by which time the pleadings be changed.
Or date.
7th August.
Monday.
Public.
Right.
I appear for respond number 1, 3, and 4. For 4, we have received the information, instruction. For 1 and 3, we have just received the instruction. Otherwise, most of his prayers are covered. Just a small portion remains. I would like to file an affidavit. The instructions are there. Some time will be granted.
Mr. A. Chetri for the petitioner, Mr. D. Bora appears for respondents.
1, 3, and
1, 3, and 4. Mr. M.S. M. Das for Beach of Property. S. Committee appears for
Respondent number
the respondent 2. M.S. Shore appears for Karbi Anglong. Mr. Bora submits that your instructions are complete.
instructions are complete.
Your instructions are complete. You'd like to bring it on record by way of an affidavit. Prayer made is allowed. Release this matter again. The month of August.
Your Lordship, first week of August.
First week of August, 7th August,
7th.
by which time the pleadings be exchanged between the parties. Ishari.
My lord.
Where is the standing council? Where is the standing council fishery? Fishery. You are eligible, you were put up for, in the first DPC, these anticipated vacancies were not taken into account. In the second vacancy, DPC, it was taken up. But instead of going for selection, recommendation for promotion, they recommended for amendment of the rules. That is okay. The rules having been amended, now you do not fall within the eligibility. When do you fall within the eligibility?
The first DPC has been, and the second DPC will.
No, now, after the
Now,
rules,
after 3 years,
after amendment of the rules, when are you eligible?
it says 5 years in the present cadre.
Hmm.
We have completed around 3 years. Another two years are there. Expenses are promoted. Year 2024 DPC says that anticipated vacancies should be taken into consideration.
All right, we'll pass orders.
Let there be a review DPC.
Had reserved.
I have prepared a small little submission.
Please.
Along with the seal of the judges.
Yes, yes.
Pleasure.
Transfer.
Lordship, my case is precisely
Let
reflected
it come in after vacation.
this stay order was passed in October last year.
So
Now 8 months she's having a stay order in her favor.
how does it affect the bank?
The bank had transferred her to Golaghat region because of the shortage of staff.
We'll examine all that after vacation.
Let a date come after. Let a date be fixed.
Matter will require some hearing. We release this matter for hearing on like 30th July 30.